The discussion really was about procedural matters and how we go ahead and proceed on some of these things. The legal memos we got were labeled privileged and confidential because that's the standard LSO mode. And we have made those public and intend to do so. A couple of the bills we've got constitutional issues are going to be important. And basically what we're doing, Mr. Chairman, is we're going to discuss the substance of those in public.
Correct.
And we did not do that in executive session, but we made it very clear that we were going to do it in public and that we wanted respectful discussion of the pros and cons on those. And we'll get it and we'll encourage that. So I do encourage the public to read those memos and don't pay attention to the privileged and confidential disclaimer on it. You can use them any way you want to.
Thank you, sir. Okay, and with that, we're going to move to item number 2, which is implementation of the 2023 Wyoming session laws. Dickie Shaner. There he is. Good morning.
Good morning. Good morning, Mr. Chairman, committee members, Dickie Shaner and Elaine Marcez with the Department of Education. Thanks for having us up here today. So what I'll do is I'll run through the memo that we provided briefly, and then Mr. Chairman, if it's okay with you, Elaine is our charter school coordinator, and I'll have her update the committee on the first meeting of the state authorizing board last week and what the actions that they took. So Mr. Chairman, pursuant to Senate Enrolled Act 80, the Wyoming Charter School Authorizing Board was established, and in this memo, we mentioned the members. There are 3 appointees from the state superintendent, 3 from the governor, and then a state board designee and a UW College of Education designee. At this time, I'd like to acknowledge 4 members of the state authorizing board that I've noticed in the audience today. We have Janine Bay-Teskey, Doug Chamberlain, the new chair, John Masters, and Cindy Delancey. You all could maybe just raise your hand or stand up and so our members. We have been providing training almost this entire year to the 3 state authorized charter schools, 1 in Platte County, 1 in Laramie County, 1 in Natrona County. And so our team, Elaine, and all of our staff with their various areas of expertise have been navigating this implementation. And obviously there's a lot to it. Particularly with all the different funding streams, federal and state, and how to either untangle that or manage the flow through from the feds to the Department of Ed to the local school districts, through the local school districts to the state authorized charters or just straight to the state authorized charters. So a lot of work still left to be done, but we've made significant progress. And I want to compliment also the resident school districts who really didn't have anything to do with the authorization of these charter schools, but have really come to the table and helped us find solutions on how to make all of this work. And they've all 3, Platte 1, Natrona 1, and Laramie 1 have been helpful when we've had questions and we've tried to work through these things. So we do have some rule changes to make with the state authorizer in terms of just updating our rules to reflect that now the authorization body is no longer SLIB, but it's now this new state authorizing board. And we will proceed with that, as well as some rules at the Department of Ed to update our standard education rules to reflect that they also will apply to these state authorized charters as well. There are 3 as I mentioned, Platte County, Laramie County, and Natrona County. They all are in different situations when it comes to facilities. So Casper has identified its own private facility. Platte County, the school district has negotiated a lease with the state authorized charter in Chugwater. And then the Cheyenne situation, we're unable to procure a facility this year, so have received an extension to go into next school year in order to be able to find a facility and get going there. And then lastly, Mr. Chair, just talking about the flow through of funding, which I mentioned earlier. The statute designated the state authorizing board as an LEA, which is a local education agency, which is a federal term for a school district. However, it can be more than just a standard local school district, and it's a federal term. What that does is it allows that body for federal purposes, so all the federal grants we have, all the federal programs we have, to sort of operate as a school district for that funding flow through. What we're running into right now is just some issues with the definition of school district in state statute and how that definition is in all of the funding statutes that we have related to the block grant. So what we're doing now, until we can work through a way to, as I said earlier, sort of untangle, is the block grant funding, the reimbursements for transportation and special education, if there are any, they're going to flow through the resident school district to that state authorized charter until we can figure out a way to get it to go straight from the state to them. So with that, Mr. Chairman, if I could hand it over to Elaine to talk about the board's meeting and the action that they took.
Good morning. Thank you, Mr. Chair. I am Elaine Marcus, Charter School Coordinator with the Wyoming Department of Education. On August 3rd, the SLIB voted to approve contract amendments assigning the authority of the 3 approved state-approved charter schools to the new Charter School Authorizing Board. Immediately following that meeting, the Wyoming Charter School Authorizing Board held its first meeting. And at this meeting, the board established their leadership as well as discussing their board practices and rules. They went on to vote to approve the contract amendments, naming the Wyoming Charter School Authorizing Board as the authorizer of the 3 charter schools, those being Wyoming Classical Academy, Cheyenne Classical Academy, and Prairie View Charter School. Wyoming Classical Academy in Mills and Prairie View Charter School in Chugwater are planning on opening their doors for the upcoming academic school year. And as Chief Shaner mentioned, Cheyenne Classical Academy presented to the board indicating that due to circumstances beyond their control, they were unable to secure a facility in order to begin operations this fall. So the school requested a deferral for their opening date to the fall of 2024. The sale of a building is pending, and they are ready to begin renovations on that building and feel confident that they will be able to be ready by next year. And the board approved Cheyenne Classical Academy's request for deferral. Their next board meeting is scheduled for August 28th at 1:30 p.m. With that, I'd stand for any questions, Mr. Chair.
Questions from me? Go ahead,
Mr. Chairman, I just wanted to report a little further. For the Wyoming Classical, it will open this fall. Expect 250 students plus or minus 10. And it is in a former public school in the city of Mills that the school system no longer used, so it conveyed to the city, which then was willing to have it used for a charter school for which it was well suited, and then didn't take much. Had to have a little repair and update, but nothing much. So we had an easy time with the facilities there. And I will mention that personally, I've been on that board trying to help the charter school get going and the movement get going. And I'm resigned effective 1st of September because they will be going. And I think a majority of the board ought to be parents with kids or grandkids in the school. And that will have that resignation will have that effect, Mr. Chairman. So I just wanted to make that additional report on the one in Casper. I think it's going to be quite successful.
Very good. Any further questions for Vicki or Elaine? Anybody? Go ahead.
Thank you, Mr. Chairman. And this is for actually Chairman Scott. What is the building that they're getting in Mills? Was it just not used because of lack of students, because there were lack of enrollment? And is the building in really good condition? And
Mr. Chairman.
Go ahead, Senator Scott.
The building was in basically in perfectly adequate condition. You know, you don't use it for years, you got to catch up on a few things. Mr. Chairman, it was full. It does not meet the state standards, particularly in parking. But it was full, but they had a chance to build a new building. The lid was off the pork barrel, and they built it and conveyed the results to the city of Mills. And so it was available. So, and Mills wanted a school. All the schools had been driven outside the city limits of Mills, and Mills wanted a school. So that was the basics there, Mr. Chairman.
Follow up?
Thank you, Mr. Chairman. And then I guess the other question I have is, when we recalibrate and when we look at facilities in our districts, when some districts have too much space and they're saying we as a state, we don't want all that space, does that extra space, when it becomes a charter, is that count against that school district, or is that the charter space? Does that make sense? Do you know what I'm?
I prefer I did.
Sorry about that.
Mr. Chairman, if I understood the question, I'm not sure I fully did. I don't think it counts against the district's allotment any. I think we get the same kind of major maintenance for charter school. Charter school is a public school and gets treated like a public school. I hope that answers the
No,
question.
that's perfect. That answered my question, Mr. Chairman. Thanks. I just want to make sure that's, yeah.
Chairman, Matt Wilmarth has.
Go ahead, Mr. Walmart.
Mr. Chairman, Matt Wilmarth, Ellis, so I can shed some light on the discussion here for the major maintenance. A charter school, if it's a facility owned by the district, shall not assess a lease payment or require a lease payment of a charter school. So an example is Snowy Range Academy up in Albany County, #1. That building is owned by the district. It doesn't charge a lease to the charter school. It's contained within the inventory of buildings of the charter or of the school district, and it computes major maintenance payments. The charter schools here in Cheyenne are separate schools not owned by the district, and lease agreements shall account for major maintenance as part of that lease agreement. It shall also be configured in a way that the block grant resources for custodians, maintenance workers, and groundskeeping are excluded from the lease payment because those are allocated through the block grant. So big picture, if it's district owned, it's part of the major maintenance inventory of buildings, it's allocated those resources. If it's not district owned, it is major maintenance is part of that lease agreement, and the lessor is responsible for the major maintenance upkeep according to statewide adequacy standards.
Thank you, Mr. Walmart. So I have a question for you, Dickie. Are the charter schools then their own separate LEA compared to the district from which they were formed within?
They are. They're part.
Okay.
So the 3 charter schools are part of the LEA, that is the state authorizing board.
Got it. So what happens if I understand, like Cheyenne and Casper, if they take the charter school opens up, takes 250 students out of Casper, for example, that money that was going to the Casper school now goes to the charter school. How does that, is that just like slamming your hand into the door and cut it off right there to the Casper schools? We usually use like a 3-year wind down on these kind of things. Is there any provisions for that?
Mr. Chairman, we've been talking through that issue quite a bit, and it's quite convoluted. And I wish that I haven't even been able to get to a point where I can articulate that funding flow through well in the circumstance of when a student, say, leaves one district and goes to another district versus when a student leaves one district and goes to a state authorized charter. But what I will say is, yes, that resident or whatever school district loses kids to the state authorized charter, the ADM will follow those kids to the state authorized charter, and that will have an impact on the school district that lost those kids.
Okay. Go ahead, Chairman Scott.
Mr. Chairman, and having had a hand in drafting that, the intent was essentially as if the kid had gone to a different school district. And the 3-year phase-in, I think, would protect the school districts as they adjust. And that, I think, was the intention of it, Mr. Chairman. But it does, it is just like the kid had gone to a different school district.
Yeah, they do essentially did. Go ahead, Representative Lawley.
Thank you, Mr. Chairman. Chief Shaner, good to see you again. Thank you for being here. You mentioned about some problems with the statutory language in terms of the definition of a school district that might need to be looked at. I wasn't clear in your statements about that, if that's something the department would be working on to try to present something to the legislature about how that statute may need to be reworded to comply with some of the funding streams and the way that they are designed.
Mr. Chairman, through you, Representative Lawley, yes, we intend to work on that and provide any sort of legislative solutions to this committee. Hopefully by next meeting. We've been pretty preoccupied with everything, getting the first board meeting stood up. But yeah, and again, it is nuanced, but an LEA is a federal designation that, and then school district is a state definition, and that school district is what's used when it comes to our funding statutes. And so we really, the goal is, in this situation, both the state authorized charter and the resident school district where that state authorized charter is located, they don't want to be entangled. That state authorized charter wants to report to the state authorizing board because that's its governance structure. And the resident school district, they don't really have any governance or control over that state authorized charter. So the goal would be to get them as independent as possible with statutory changes.
Thank you.
Go ahead, Representative Brown.
Thank you, Mr. Chairman. Dickie, Mr. Shaner, out of curiosity, you guys have, either one of you guys have enrollment numbers for the Chugwater area. And what I'm kind of curious on is kind of looking at, as we've discussed this briefly, and I think one of the pieces out of the Senate file that we passed last year was to talk about the cost associated with these. My direct question is I'm trying to get to an understanding of how many students are left in the Chugwater public LEA versus the state LEA now, and what that may do to the funding mechanism. Does that move them into a different level of, as far as being a smaller school district? So then we have to heighten their ADM, per ADM, stuff like that. So I know that's a convoluted question, but I think you get where I'm going to.
Yeah, Mr. Chairman, through you, Representative Brown, as to how many students are going to be enrolled in the charter school in Chugwater, there is a representative here. Christian, how many? You? 70. Pre-registered. Okay, so Mr. Chairman, through you, Representative Brown, there's about 70 kids that are pre-registered. And the way that will work is under the law, they were all required to send a March estimate to the department. And that's how the funding will start. And then there'll be a true up in October with the actual enrollment. And as far as any other public, there won't be a public school, as far as I know, in Chugwater, a Plat 1 school in Chugwater. The charter school is public, but it will be, that facility in Chugwater will be used by the charter school.
Mr. Chairman, just follow up. Go ahead, follow up. So it's my understanding, let's just use round figures here, because I have no idea what's going on in Chugwater, but let's just say there was 78 students in Chugwater. Those 8 students now then are being bused from Chugwater up to Wheatland or some other school. Then they're not staying in that locale. They're being bused somewhere else. And is that right?
Yeah, Mr. Chairman, through you, Representative Brown, that's our understanding.
Okay, thank you. That's all I needed.
Representative Clausen, go ahead.
Thank you, Mr. Chairman. Mr. Shaner, Casper say 250 students will be leaving that school district. So $4 million in funding out of the Natrona School District towards the new charter school. Do we know if the school district in Casper, are they having less classes? Are we cutting teachers? Are we closing schools? How does that 250 students affect the current school district?
Yeah, Mr. Chairman, through you, Representative Clouston, we're not privy to the discussions at Natrona One in terms of how they're going to deal with that ADM impact. But I can tell you that we've had a lot of conversations with them about this process, and so I know they've been working on it all year. So I'm sure that they have a plan.
Further questions for?
Marcus.
Thank you.
Anybody like to comment publicly on implementation of the Wyoming session laws? Go ahead, sir.
Mr. Chairman, Committee, Nathan Winters from the Chairman of the Board of the Public Charter School here in Cheyenne, Cheyenne Classical Academy. I just want to sit here and give my appreciation to the new authorizer board. The way they established themselves and also the way they handled the business that came up this last Thursday was impeccable. And so I just want to express my appreciation. They were very thoughtful in the questions they asked. And so I was appreciative to see how it flows through that board. The second thing I want to say is I have been part of the conversation with the WDE. I've attended several of their meetings, and they were right. There is a question regarding the flow-through, the pass-through of funding, and it's just kind of the question as to which way the funding will come. And so I'm appreciative also of the work that they're doing to try to bring you solutions on how to smooth that out and make it clearer than the legislation was last year. So with that, thank you. I'll stand for any questions.
Mr. Chairman, you have one online as well.
Good morning, Mr. Chair, members of the committee. Matt Flett, Chief Financial Officer, Natrona County School District Number 1. I want to come up and shed some light on Representative Clauston's question about ADM loss to Wyoming Charter or Wyoming Classical Academy. How we handle that as a district is through staffing. So we will reduce sections in elementary schools, the middle level if necessary, and just reduce staffing. So I just want to shed light on how we handle that. And we think that's prudent of the taxpayer dollars to adjust staffing to match our enrollment. And Representative Northrup, to your question about, we are also working through that with Mr. Shaner and WDE about the revenue loss for ADM. We still are working through, is this going to be a $2.8 to $4 million revenue loss for us yet this fall? Or is it going to go through the 3-year averaging? Like, we still aren't sure on that. And I mean, with it being a potential multi-million-dollar revenue loss this fiscal year is something we definitely want to figure out sooner than later with the department. So.
I'm sorry, Senator.
Thank you, Mr. Chairman. Why wouldn't it go through the 3-year averaging? I don't see any reason why it would possibly be instantaneous.
Mr. Chair. Senator Rothfuss, thanks for that question. That is, I believe, an administrative rule, Title 8, Section 8. It's somewhere around, it's in WD's rule set in one of the sections. Mr. Shaner may be able to shed some more light on that rather than I can. That's just one of the discussions we're having.
Go ahead, follow up.
It's in rule, but it's statutory. The 3-year average is statutory, and that statutory is based on district enrollment, and it's smoothed over 3 years for a decline in district enrollment. I don't see how there's any ambiguity, so maybe we do need Dickie to come back up. I don't understand where we could see any ambiguity, so thank you for raising that.
Thank you, Mr. Chairman, through you, Senator Rothfuss. There are rules at play, and dealing with situations with a student transferring out of a district. And so, as I said, we've spent a lot of time trying to sort through that, and we want to get a memo put together with the rule changes that are going to have to take place, because we're going to have to do some rule changes, I think. And Really just explain it because it's difficult for me to sit up here and like articulate it well, but it's not apples to apples when a kid leaves a district and goes to a state authorized charter versus when a kid leaves a district and goes to another district because of the Chapter 8 rules.
Thank you, Mr. Chairman. And maybe you went over this already and you can answer this. The other question being, if, say, charter school closes or students leave in large number from the charter school to a public school, what happens with the funding for that public school then? When do we see that they are able to get the ADM that's appropriate for them?
Mr. Chairman, through you, Representative Parenza, the ADM would go back to the school they attend.
Thank you. And thanks again. I do understand that you're not prepared for this line of questioning and you basically want to go back and do the research. But what I would note is we talked this through as we were working this over the last couple of years, and certainly this last year as we were working on that final draft, and contemplated the fact that the 3-year average would be a mitigating factor for this change. I don't see ambiguity in the law, so I guess I would ask that this be a priority for you all to research as quickly as possible. So if there is a need for statutory change because we didn't get it right, we need to do that very, very soon. So please, if you can prioritize that, thank you.
Particular request because like Senator Ruffus, I thought the law was pretty clear. So if this, you need to get the rules straightened out, and if it's a problem, let us know. I do have a question, and that is in the charter school. I know that the charter school was recruiting from the Natrona County School District, and with some success. And I don't know how many of the teachers, and I think the headmaster came out of the Natrona County School District, was a principal. Do you know off the top of your head how much of your staff went to the charter school? Because that does ease the problem if the teachers in the charter school come from the school district.
Go ahead, sir.
Mr. Chair, thank you. Senator Scott, thanks for that question. We'll have to follow up with you on that. I don't know off the top of my head. I don't even really know.
I should know, and I don't, but I do know they were recruiting there, Mr. Chairman.
Mr. Brown, you had a question?
Thank you, Mr. Chairman. So I'm going to take it one step further from the chairman and Senator Rothfuss, and just, I guess I would be pointed in saying the intent of the legislature was to ensure that this was a 3-year rolling average. And so as I just pulled up Section 8 in Chapter 8 here, I see where there could be ambiguity. I already see exactly what you guys are talking about. I guess from my point of view, and I would guess I would be speaking on behalf of the rest of this committee and probably the rest of the legislature, it was the intent of the legislature to give that 3-year rolling. So I would encourage the state board and the department to promulgate those rules effectively with that intent. I don't see why there would be any ambiguity. I don't think there is any ambiguity, and I don't think there should be any statutory change. That statutory change was made with that intent, and I think that was fairly clear. So I would just encourage the Department of Education and the state board to look at that and make sure that you guys adopt rules as the intent of the legislature. So thank you, Mr. Chairman.
Mr. Chairman, I would add, we I think finally arrived at sort of a comprehensive way to deal with the issue just early last week. So, now that we think we have a plan to articulate, we're happy to do that in a memo form and just provide it to the committee when we can, even, before the next meeting, once we put all that together. But
Representative Lawley, you had a question?
Yes, thank you, Mr. Chairman. Dickie, I agree with that. We discussed at the committee level this idea of the 3-year rolling average to provide some continuity. But to Representative Provenza's question, do you envision that which way we go with this would be done both ways? If a student then leaves a charter school to go back to another school, or would it be done differently? How would the adjustment be done?
Go ahead, Mr. Shaner.
Yeah, Mr. Chairman, through you, Representative Lawley, I don't want to speak inaccurately because, again, I'll tell you, like, we've spent hours with school district professionals, with our finance team, going through our rules, going through all the applicable statutes. So I don't want to give you an answer that's inaccurate, other than to say, substantially, the ADM will follow those kids wherever they go. There's nuance to that, but
Go ahead, Representative Berger. You have a question?
Yeah, thanks, Mr. Chairman. And real quick, so again, I'm clarifying stuff. So Mills bought the school or the facility, and then your district, it's no longer to take care of maintenance wise. So can the charter pay for you? Would they pay for you if they need major maintenance from and use your staff, or would you just donate that? Or I just want to make sure, because it's a public school, that the facilities are staying adequate, or very nice, because we have great facilities for these kids that are going to school. I just want to make sure that everybody has nice facilities when they go to school, because it is a public school.
Mr. Chair, Representative Berger, thanks for that question. It is technically a city building. We sold the Mills Elementary a number of years ago, or gave it to the city of Mills. It's a city of Mills building, so I would assume through their lease process, as Mr. Wilmarth alluded to earlier, that would be part of the lease with that school, is the city would provide major maintenance, or whoever the contact would be there. And we are out of that facility maintenance question completely. Good question.
All right. We'll go back to public comment. Anybody else like to comment publicly? Going once, going twice. All right.
Mr. Chairman, did you want
Oh, yes,
the?
there's one online. That's
Okay.
right. Thank you.
Yep, so I'll bring Carol Kane in right now. All right, Ms. Kane, whenever you're ready, you can turn on your camera and your microphone.
Hello, my name is Carol Kane. I am from Sheridan County. And I, first of all, would just like to express my thanks and appreciation for the state authorizing board for all the hard work they're doing. It's exciting to see Wyoming grow and adjust and put forth this hard work to make charter schools available. I am a founder of Cloud Peak Academy, which we applied for to be a charter school for grades 6 through 12 here in Sheridan. We applied to Sheridan County School District number 2, and we were denied yesterday because our application was late. I've talked with the school district, and so I just wanted to give my input to you guys so that you're aware of the situation we had. The deadline was confusing because it seems to be different, and it was hard to keep track of when the deadline was for this year versus last year. Another thing that was confusing was the application online itself was not confusing, but I guess I kind of assumed that if I was going to be late or too early to apply, that I just wouldn't be allowed to apply. So if there would be a way to make that window more obvious to applicants would be nice. And also, I don't know why the window for applying is so short. If there's a reason behind that, maybe that could be explained more obviously to us lame folk in the state. But I mostly just wanted to say how grateful I am for the efforts that everyone's putting in for the charter schools. We're very excited to see how this will progress. Thank you.
Thank you, Connie. Does anybody have Miss Connie, does anybody have a question or comment for her? Thank you for your comment. Anybody else? Anybody online? Anybody publicly here? Okay. With that, let's, I have 9:35, we're a touch ahead, so let's take a 15-minute break and we'll come back and start in on 24 LSO-0052 Education Savings Account, and that will be at 9:50. So if you gotta go pee, go. Well, Verizon says it's 9:50, so we're back. We'll call this meeting back to order. We're now on 24 LSO-0052, the Education Savings Account. Speaker Summers, would you like to give us an introduction into the bill?
Mr. Chairman, fellow committee members, Mr. Co-Chair, thank you. So, as we got out of session last year and we got into after the interim topics were assigned to education, and they were early, number 2 and number 3, I think, were early childhood education and school choice. So as I got to thinking about this, and this idea really wasn't entirely mine, it was mentioned to me, and I'd also seen some things in some other states. So anyway, the idea, well, is there a way to merge these two concepts? And so if we pack a educational savings account, if a parent can pack that to a private school or a homeschool program, why couldn't we pack that to an early childhood program as well? We struggle at times to find funding for early childhood programs, and certainly I think it was a good mesh, frankly. I think it works for both sets of students. And so when I was looking at it, I decided, well, I want to try to make this as constitutional as I can. And I also wanted to make sure we hit a population of children that weren't the richest of the rich, right? And so how do we do that? And so, but primarily on the constitutional issues, I got to thinking and I got to looking at what I feel are the constitutional constraints of an ESA. But I think in statute or in our Wyoming's Constitution, we have a provision that says you can provide aid to an individual if it's for relief of the poor. And the courts have basically broadly interpreted that over time. And so you will see in this bill where this is an ESA that will be for children or for families, I guess you would say, that are 250% of federal poverty level or lower. That's about $75,000 of income for a family of 4, according to the little calculator on the internet. And so the bones of this bill are basically the bones of the bills that were from last session. I reduced the individual ESA amount from 6 to 3, thinking that would pick up more children without putting in more money. I think, and the point was raised to me, if you're kind of going after low middle income children and lower, maybe 3 is not enough because it still won't help them enough. So certainly, I can understand if the committee takes up this bill, if they were to up that, I would be supportive of that. The split 50-50 was simply a placeholder between early childhood and the K-12 piece of this. I would certainly be willing, I certainly would agree to something like a 30-70 split where 70% is the K-12, where there's more students in that. The other concern I hear about, and because I do have a couple of more items in here. One was certification of schools. I've seen this in other ESA bills in other states. I leave it pretty broadly open to WDE to determine that, and really the only condition in the bill on that issue of certification is that you have to teach this number of courseworks, math, science, et cetera, civics. And those were actually in the other bill, but not in a certification process. I do think we have to have, anytime the state spends money, I think there has to be accountability and there has to be transparency. The other one I have in there is the state test, and I put that in there for constitutional purposes. I believe by having that state test, I think it helps make this more satisfy the constitutional requirement to provide an adequate education. So I think we can see with these students, how these students are performing with other students. And then it's also a transparency issue for parents. They can see how these students are performing. There's been suggestions of alternate testing language. You know, that's up to the committee, and I'm not entirely opposed to that either. I think there's some mechanisms you can do there to have other testing and still be able to, for a parent to be able to review across the board, across all schools, kind of how their child's doing, or at least how those schools stack up, not so much maybe their child. And so that was my intent, was to provide a vehicle for funding for both school choice and early education, both of which I believe are important to parents in the state of Wyoming. So, thank you. And with that, I'll turn it over to Tanya to walk you through the guts of the bill.
Mr. Chairman, members of the committee, Tanya Heitrick, Legislative Service Office. I'll go ahead and walk you through 24 LSO 0052 Educational Savings Account. As the speaker mentioned, this authorizes educational savings accounts up to $3,000 per individual. Eligibility is based on 250% of the federal poverty level to be used to pay for qualified educational expenses, which are also defined in the bill. As far as who's eligible, as the speaker mentioned, it's available for children ages 3 through completion of high school or some type of equivalent certification. There is $40 million from the general fund appropriated to the expenditure account, which is created by this act. And it authorizes 2 FTE for the Department of Education to implement the program. Walking through the bill, section 1, page 2 through 23 creates the Wyoming Education Savings Accounts Program, creating 9.2.101 through 9.10. The definitions are contained on pages 2 through 4. I would draw your attention to the definition of education service provider, which can be found on page 3, lines 7 through 12. Which includes a person, organization that receives payments authorized for the educational goods and services, and it includes payments to a qualified school. And a qualified school, I would also draw your attention to that definition, which can be found on the bottom of page 3, lines 22 onto page 4 through lines 3. And you'll note here, it includes a preschool or non-public primary or secondary school certified by the state superintendent. Moving on, page 4, line 8 through page 6, line 3, this authorizes the $3,000 payment per year, as we spoke of earlier, and provides payment will be made to the ESAs by the state treasurer as certified by the state superintendent. It creates an educational savings account expenditure account. This is similar to other scholarship programs, the Hathaway's scholarships, the Wyoming Works program. Those have expenditure accounts tied to them as well. Moving on, page 5, lines 8 through 16. Again, this is similar to other school accounts and requires that any amount over scholarship accounts, sorry, not school, scholarship accounts, requires that any amount over $40 million and 150% of the amount required to fund all educational savings account is transferred back to the general fund. Page 5, lines 18 through 20, this provides that the ESAs are distributed on a quarterly basis. Page 6, lines 1 through 3 requires the state superintendent to quarterly certify the amount of the educational savings accounts to be paid by the treasurer. I would note that's a substantial deviation from the legislation that we saw last year. This does have the state superintendent administering the educational savings accounts program, with just the state treasurer managing the financial aspects, payment to the financial institutions as certified by the state superintendent. Wyoming Statute 92904 establishes eligibility requirements, requires a parental agreement, and outlines the administration of the educational savings accounts. Page 6, line 8 through page 7, line 4 provides that any child at 250% of the federal poverty level as determined by the most recent federal guidelines and that has not graduated or completed an equivalent and is eligible for public school is eligible to participate in an ESA. And then secondly, also as a requirement that they are 250% of the federal poverty level and that is at a minimum 3 years old as of August 1st and has not yet attained the age to attend public school. Page 7, line 6 through page 9, line 16 requires an agreement between the parent and the state superintendent outlining that the educational savings account will be utilized to pay for qualified expenses. You can find those qualified expenses beginning on page 7, lines 13. It includes things such as tuition and fees as a qualified school, which we discussed the definition of that previously, tutoring services, services provided by a public school district on a part-time basis, textbooks, curriculum, computers, educational software, school uniforms, fees for nationally standardized assessments, tuition and fees for summer education programs, after-school programs, instructional materials and tuition and fees for career or technical schools, tuition and fees at an institution of higher education, transportation on a fee-for-services basis, and any other educational expense approved by the state superintendent. There's sort of a catch-all on page 9, lines 15 through 16. Page line 918 through page 11, line 3 specifies the provisions applicable to those students qualifying for the ESA that are of the K-12 population. You'll note in several instances there are provisions that apply to that population that will not apply to the preschool population. And again, as the speaker pointed out, it requires that at a minimum reading, writing, mathematics, civics, history, literature, and science are taught to those students. This definition is similar. I think it's actually identical to what homeschool students are required to certify to their district every year. On the top of page 10, lines 2 and 3, this requires that those same students take the statewide assessments administered by the State Board of Education. And then moving on to lines 6 through 10, certifies that the student is not enrolled in a public school while receiving ESA funds and releases the school districts from obligations to educate that student. Page 10, line 12 through page 11, line 3 provides eligible students are not required to withdraw from a public school before requesting an educational savings account, and that students are not prohibited from applying for an educational savings account for the upcoming school year. And then lastly, it provides that nothing prohibits a school district from charging services that are provided to those students that decide to participate in an educational savings account, like on a part-time basis, say. Page 11, lines 5 through 8 prohibits refund, rebate, or sharing of the educational savings account with the student. Page 10 or page 11, lines 10 through 13 authorizes parents to pay for those educational services that may not be covered by the educational savings account. Page 11, lines 15 through 21 provides that the educational savings account will remain open and those funds will not revert until the student is either no longer eligible or withdraws unless the account is closed for substantial misuse. And then in that event, if it's closed for substantial misuse or this, it will be reverted to the general fund. Page 12, lines 1 through 3 clarifies that an educational savings account student is not required to be enrolled full-time or part-time in a non-public school. Page 12, lines 5 through page 15, line 7 creates 92905. These provisions outline the application and award and the allocation of the educational savings account. It requires that the student or the parent of the student apply to the state superintendent, that the state superintendent establish a process and an application to expeditiously approve and review applications and ensure that that form is publicly available on the internet. It also requires the state superintendent to approve an application if the parent applies, if the student is eligible, if funds are available, and the parent assigns the agreement required as previously discussed. Moving on to page 13, line 17 through page 14, line 3. This provides, as the speaker pointed out, the 50% allocation to the K-12 population and 50% allocated to the pre-K population. It also provides that in the event that there are inadequate funds, the scholarship or the educational savings accounts will be awarded on a first come, first served basis. Page 14, line 5 through page 15, line 7 specifies the requirements again for the K-12 educational savings account students, including that providing the educational students with notice to the home school districts. This is very similar to, again, to the homeschool provisions. They're required to provide notice to their home district every year to ensure that they're being educated. And then moving on, it provides that they may cease participation and enroll in a public school. They're authorized by the state superintendent it authorizes the state superintendent to enact policies to ensure that the least disruptive process for students in returning to schools. Page 15, we're about halfway done, just so everyone knows. Page 15, line 9 through page 21, line 20 creates 21-9206. This identifies the duties of the state superintendent in administering the program. It establishes a certification process for the education service providers that at minimum ensures that the K-12 students receive instructions in those areas identified previously. Page 16, lines 1 through 5, requires that the state superintendent provide a list of certified educational savings account providers that includes whether the program is accepting new students or not. Lines 7 through 11 requires that she provide a written explanation of the qualified educational expenses. Lines 13 through 21 requires that K-12 students ensure understanding that for K-12 students, participation in an educational savings account is a parental placement under the Individuals with Disabilities in Education Act. Page 16, lines 22 through page 17, line 6 authorizes the state superintendent to contract with private entities to administer the program. Some states have contracted with banks to hold the funds and provide the students sort of debit cards to utilize. That's one option. There's a myriad of different organizational options that could be pursued. It kind of leaves that up to the state superintendent to identify that. Page 17, lines 8 through 19 requires the state superintendent to implement a commercially viable, cost-effective, and user-friendly system for payment. Those must be online, by electronic means, or by online fund transfers. Page 17, line 21 through page 18, line 12 requires that the state superintendent certify the deposits for the educational savings account. Page 18, lines 1 through 12 identifies means for when the student is no longer participating or when they're no longer eligible for the program, and she can cease providing funds to that particular student. Those are identified if they're no longer eligible, if there's an intentional and substantial misuse of funds, if the student withdraws, or if the student enrolls in the full-time public school. Page 18, line 14 through 17 requires that the state superintendent audit 20% of randomly selected educational savings accounts. Page 18, lines 19 through page 19, line 8 requires that she investigate reports of intentional and substantial misuse of educational savings account funds and prohibit receipt if the state superintendent determines that this occurs, prohibit future receipt. Moving on, it requires rules to establish a process to make such a determination and authorizes her to refer cases to the Department of Audit and the Attorney General's office if evidence of fraudulent use is obtained. Lines 10 through 20 establishes rules, authorize her to establish rules to prohibit acceptance of ESA providers if the state superintendent determines if any of those items listed on lines 15 through 20 have occurred. Those include intentional and substantially misrepresenting information, a failure to refund any overpayments, or routinely fail to provide students with required educational goods and services. Page 19, line 22 through page 20, line 2 requires notice within 10 business days to the students and the parents in the event that the superintendent determines that an educational service provider should be prohibited from accepting future payments. Page 20, lines 4 through 13 ensures that K-12 students participate in the required statewide assessment and that the state superintendent compile those results to analyze student proficiency and academic performance. Page 20, line 20 through page 21, line 2 authorizes partial payment of an educational savings account in the event that a student needs to reserve a spot for an upcoming school year. It provides the process in the event that the student doesn't attend that, that it's paid back to the educational savings account. And as well, the future payment, the future quarterly payment will be reduced by any amount sort of advanced initially. Page 21, lines 4 through 20 authorizes the state superintendent to adopt rules necessary to administer the program, including a service for fraudulent reporting, an anonymous telephone hotline for fraud, a requirement for a surety bond for educational service providers receiving more than $150,000, as well as refund procedures. Page 21, line 22 through page 23, line 5 creates 21-2-908 governing educational service providers, including a requirement that those providers are certified by the state superintendent and agree not to share any of the proceeds with the educational savings accounts parent or student. Moving on to the bottom of page 22 and on to page 23, paragraphs B, C, and D clarifies that the educational service account, or excuse me, educational savings account providers are not agents of the state or the federal government, that they are independent and retain autonomy to the greatest extent possible, and they have the maximum freedom to provide instruction and deliver education in a manner that doesn't obviously contradict other provisions that we've identified. Page 23, lines 7 through 15 creates 21-2-909, and this identifies the responsibility of the public schools and the districts to provide a copy of the student's educational records to educational service providers as needed in a manner that conforms with the Federal Family Educational Rights and Privacy Act. Page 22, line 17 through 22 creates 9-2-910. This specifies sorry, I lost my place here. Oh, this specifies that no liability shall arise on this part of the state superintendent or any public school or school district based on the award or use of the educational savings account. Page 24, lines 1 through page 27, line 7 contains conforming amendments. This is section 2. You'll note lines 4 through 11 on that same page. Amends 21-4-102. This is the compulsory attendance law. And requires that the educational service, that the child participating in the program provide notice to their local district. Page 24, lines 13, on to page 25, lines 1 through 19, creates a new section and modifies 21-4-301 to specifically authorize a student participating in the program. That this is specifically authorizing a student participating in the program that's eligible for public K-12 school has the ability to participate in the educational savings account. Page 25, lines 21 through page 27, line 7, modifies 21-13-310. This excludes the tuition received by a school district to provide services to an educational savings account students in a partial manner. It treats it similarly to in the event that a district provides partial educational services to a student. You can see page 27, line 2 for that insertion. We're just about done. Page 27, lines 9 through 14. This creates section 3. This is the $40 million appropriation from the general fund to the educational savings expenditure account, which I referenced previously. And page 27, line 16 through page 28, line 5 creates section 4. This allocates the 2 FTE and the associated funding to the Department of Transportation to administer the funds. You'll note that we need to insert the amount there on page 27, line 18, and then on page 28, line 2. Page 28, lines 7 through 12 creates section 5. This authorizes the state superintendent to take actions necessary to enroll in the program for school year 25-26 with applications beginning to be accepted on January 1st of 2025. Section 6 on the bottom of page 28 contains the effective dates. Sections 1 and 2, which are the statutory revisions, are effective January 1st of 2025. And section 3, which is the appropriation, is effective July 1st of 2025, and leaving sections 4 through 6 effective immediately. That is a lot of information, so subject to your questions.
Mr. Chairman.
Go ahead.
Mr. Chairman, just a couple of comments. So obviously, I chose the Superintendent of Public Instruction, WDE, to place this. I just think they have more expertise. The number of employees they may need or not need is a WAG, not even a SWAG. And so it's, that's a discussion, I think, with WDE on what they may need to administer, particularly if they contract much of it, so that would be that. So thank you, Mr. Chairman.
All right, Chairman Scott, go ahead.
Okay, Mr. Chairman, I have several questions, and they'll be for the speaker. And first, let me compliment you, Mr. Speaker. That's a creative solution to the early childcare preschool issue. And
point of order, Mr. Chairman. Can I have a point before the good co-chair?
What is your point?
My point is, the last action the committee took on the school choice House Bill 194 was during the interim topic selection. We voted to take up House Bill 194. This is not House Bill 194. No, it's nowhere close. My question is, when did the committee, not somebody outside the committee, vote on this bill draft to be introduced and to take this committee in this direction? This is not a committee directive. This is outside the committee. So what we're doing is, if we continue down this path, we're starting in a completely different place than where we began, where the committee decided to start. So my question to the co-chairman is this normal for somebody outside the committee to direct LSO in the direction of a bill draft for a different committee? And that, I've never seen this happen before. So a little bit of education would be great. Thank you.
Go ahead, Speaker Summers.
So, Mr. Chairman.
Yeah.
So, Mr. Chairman, just from my perspective, when you had an earlier meeting in public comment, I brought the concept to you all and said I would bring it to the chairman. And then I got permission to bring it here, as far as I know. So that's the route I went. Senator Biteman. As to whether people bring bills to committees or not, I don't know. Sometimes they do, sometimes they don't.
We've always allowed people to bring, somebody to bring a bill to the, if it's an education bill and it's relevant to our management directives, and we've been able to look at it and we'll decide whether or not we want to make it a committee bill or not, or leave it as a personal bill in the past when I was chair. Go ahead, sir.
Yeah, and Mr. Chairman, our specific charge is on school choice. Committee will review aspects of school choice, including a review of HB 194. Wyoming Freedom Scholarship, and then SF 143, Wyoming Freedom Scholarship Act 2, committees, et cetera. Mr. Chairman, I think any bill that's in this area is within our charge from the Management Council. Now, if we want to decide to come forward with a bill that is much closer to 194, that's fine. But when the speaker volunteers to do some work for the committee and provide a choice, I think we're obliged to take it seriously. So we haven't made any decisions as to what we're going to do going forward. I think we're going to frankly hear a lot of testimony today and carry the whole thing forward. And Mr. Chairman, I think it'd be in order to substitute 194 at the next meeting, or a modernized version of that, if somebody wanted to. Doesn't mean you got to do the work. And I'm going to have some suggestions I'm going to ask the speaker about, but I think they would apply also to 194.
May I?
Go ahead.
With all due respect, though, the speaker is not a member of this committee, and I just don't think it's appropriate for somebody outside the committee, whether they're in leadership or not. I guarantee if I were to show up in somebody else's committee, I'd be thoroughly dismissed because I don't carry the title of speaker or president. So I think going forward, this type of action should be dealt with caution. Thank you.
Thank you, Senator Biteman. Go ahead, Representative Provenza.
Thank you, Mr. Speaker. Mr. Chairman, on the minute notes of the committee meeting, because I asked that question as well, it's in there. Committee directed LSO to work with the speaker to draft an ESA bill to be considered. So I don't remember who made the motion, but we have record of.
Okay. You had questions?
Yes.
Chairman Scott, go ahead.
Mr. Chairman, got a couple of things. First, I do think that the approach on the preschool is creative and something we ought to consider very carefully, Mr. Chairman. Several questions. One of the constitutional concerns that was raised with the bill draft as it stands before us, which I think is present in the other bill draft as well, is that putting the money in the accounts for the people to use directly could be construed as appropriating to somebody not on the absolute control of the state, which is the constitutional provision. We have dealt with this traditionally by appropriating to a state agency and then paying for services. And the closest parallel I can find is the Hathaway program, scholarship program, where we appropriate, in that case, the Community College Commission. In this case, I would suggest maybe the state auditor might be appropriate. And then people have the scholarship, they're granted the scholarship, and they basically enroll in particular community college, and the college then, or the university, the academic institution bills the state, and the state pays that for services rendered. if we were to change the language in this bill for a procedure that followed that route, would you have any problems with that? That's, Mr. Chairman, that's first. I got several other questions of that.
All right, Mr. Speaker, go ahead.
Mr. Chairman, if you've got a better way to do that, that's fine. I basically just took the bones of the old bill and I made it as constitutional I could by going to a poverty level, which, I think you could go a higher poverty level. I do believe that a poverty level of some kind is important, at least in my perspective, because I don't know that I want, I know that I wouldn't want to fund billionaires to put their child in a private school in Jackson, for example. So I don't think that's a good use of state money. And so that's why I went with the poverty level piece, because I think it makes it more constitutional to go down that path. But, if you got a better mousetrap like that,
Mr. Chairman,
let me know.
Ms. Heitrich would like to comment. Go ahead.
Mr. Chairman, I would just also point out that under the Hathaway Scholarship, those are state institutions that are receiving the money. Those are state entities. It's the University of Wyoming and the 7 community colleges. And so there is a distinction there from a constitutional perspective.
Go ahead, Chairman Scott.
Mr. Chairman, but we've done it in many other areas as well. On the business of the means test, I think that's maybe necessary in the preschool area. Maybe it certainly helps. I think in the K-12 area, we probably don't need that, except to control the total amount of expenditure here. That's a matter of opinion and debate. On the issue of limiting the expenditure and getting the most bang for our buck, couple of things. One, I talked to a senator who's involved in the parochial Catholic schools, and he told me their tuition is typically $5,000 a year. If we're talking about directing this to people who are of limited means, particularly the lower end of your range, it would seem to me we almost needed to pay the full tuition rather than a portion to make it workable, Mr. Chairman. So I'd like your opinion on that. And also have thought about if we needed to limit it so we could fit it within a budget, should we limit it to the schools that are least successful in the primary grades? Say the ones that are show on the YTOP test as under 50% in proficient advance on third grade reading, which wouldn't, people in Pinedale's district wouldn't be eligible. Big Piney's would. The 3 largest districts are not performing well and would fall into the category. That's a technique that's been used elsewhere. I don't know exactly the measures they've used, but they have tried to confine some of these things initially to the failing districts. Is that something we should think about? And then, Mr. Chairman, again, going back to the Hathaway experience, what they did there, and it was actually the House Education Committee that did it, Mr. Chairman, was structured, they took my bill and structured it such that the principles of the scholarship program were enacted. And then that enactment created an implementing committee that dealt with all the administrative details, which I'm a little afraid might overwhelm us. And would that be an acceptable result from this committee? And that would apply to the 194 as well.
Speaker Summers.
So
you remember all that?
So, Mr. Chairman, well, on the first issue of the grant award of $3,000, I agree. Since I created the bill and have had discussion with people, there is that concern that if you go with 300, 250% of poverty or whatever, then will these kids have enough money at all at 3,000, or these parents at 3,000 to be eligible for a program? And so I agree that that probably needs to be raised. You know, where, if you want to go clear back to the 6, that's up to you. Just as we all know, that's going to limit the number of parents that get that, or the number of children that get that. So you've got to, I think you guys can ask and answer those questions. You know, as it relates to, what was the second one?
Means test.
Means, the means test and using it, I guess that was more an opinion on my part, as relates to limiting the expenditure by limiting it to the schools that are not performing well, limiting to people that live in those districts.
Right. So, Mr. Chairman, Mr. Co-Chair, thank you. You know, I think it would limit it too much. I think if, you know, you can limit it by the means piece, you can do, or you're going to limit it by first come, first serve. You're going to limit it just by the amount of money you have. But I guess I would be hesitant to go down that path of limiting it to just those schools that are not performing well. Because that might, I just think that's maybe a bias you don't want in the system, but that would be just me, Mr. Chairman.
And then, Mr. Chairman, the question of enacting the principles and an implementing committee.
You know, Mr. Chairman, Mr. Co-Chairman, you know, oftentimes we get real explicit in statute, and oftentimes we leave it to rule and regulation of the department. I don't mind either way. I think when you leave it, you know, I guess I don't understand what an implementing committee is. So does that mean you're going to create a committee, like a task force within WDE that will give recommendations to the superintendent to provide rulemaking? I don't really know how that would work. So, Mr. Chairman, I don't quite understand how.
Mr. Chairman Scott.
Mr. Chairman, what I'm thinking of is specifically what we did in creating the Hathaway. The House Education Committee took a bill that we sent over in the Senate, and I know very closely because it was my bill, that had a scholarship provision in it, just pretty plain vanilla. Put in what became the full Hathaway, named it as such, found $400 million to fund it, $400 million to fund it, and created a committee to work on the details of how it was to be managed. And that committee came up with precisely who was eligible, came up with the system for flowing the money, came up with a success curriculum after educators committee had failed on that particular score, and dealt with all the administrative details that you have to put in statute to make it work. And some of those complications are in this bill already, but they can be complicated enough to hang a bill up and cause it to fail. And I thought it was a stroke of genius to enact the principles on that and the committee was a mixture of 4 legislators and members appointed by the governor and I think the state superintendent from the public and interested parties. And the co-chairman wound up being Senator Tex Boggs, who was president of Western Wyoming Community College, and Representative Steve Harshman from Natrona County. And frankly, Jeff Wasserberger and I were on it too, and we railroaded the chairman's selection a bit. Mr. Chairman, and it worked because you didn't have the bill go down due to arguments over technical details. So it's an approach that particularly going to a budget session, I would commend to the committee's consideration, and I'm wanting to get a reaction out of the speaker, how he feels on that.
So,
Go ahead, Mr. Speaker.
so Mr. Chairman, you know, I think you enact a bill, and I think it can have all of the, I call it bones that this has. And then, obviously, you're going to refine that over time. So if you wanted to also create in the bill a task force to evaluate more in the next interim to make those changes, you know, and bring that as a bill, I think that's a reasonable thing to do. I mean, you're going to find things that work and things that don't work, things that are needed and things that aren't needed. And that's just going to be a function of implementing anything that's 30 pages long as a new program.
Representative Lawley, you had a question?
Thank you, Mr. Speaker. First, I'd like to go back to something Senator Scott raised about the idea of workarounds that have been done from time to time when the legislature determines that this is a policy direction they want to take, and then trying to work around, which in some ways this bill has done, some of the constitutional provisions. And in particular, the issue that you and I've talked about, Tanya, about the Stevens School in the Wind River Reservation, where the Attorney General opinion of 2016 that spoke to the issue of government, you know, absolute control and using education funds for that endeavor because it wasn't a school district. And they found a way. There was a way around it where they created an entity, the tribes created an entity that then interacted with the Department of Education. They had a contract and some things. So I just wanted you to speak to that a minute about, again, doesn't exactly parallel with the educational savings account, but it was an attempt by the legislature when there was a compelling public policy direction to find a way to address those issues. And to me, that is an example of that. And there may be others, but that's just what I'm aware of.
Go ahead, Tanya.
Yes, certainly, Mr. Chairman, Representative Lawley, I think you're speaking about 21-4-601, which speaks to educational programs on the Wind River Indian Reservation. And I guess one point of clarification is that St. Stephen's isn't specifically mentioned in the legislation and wasn't. And I suspect, although I wasn't here in 2007 when that statute was enacted, I suspect that that was part of the discussion about how they created that particular mechanism to get funds to those children. But certainly, I mean, these are all policy discussions, and I don't know that anyone can sit at this table and tell you definitively this is constitutional or it's not constitutional. You know, there hasn't been a case like this before the Wyoming Supreme Court. There hasn't been a case like this before the United States Supreme Court, taking into consideration Wyoming's constitutional provisions and our school finance litigation. So to your point, yes, there have been instances where the legislature has made a public policy determination, you know, and taken a calculated risk. I would also point out that program wasn't challenged. And we also talked a little bit about it's not a one-to-one sort of comparison between the educational savings account bill and this, how the funds found their way to St. Stephen's School.
Mr. Chair, quick follow-up on that point.
You got a follow-up? All right, follow-up first.
Again, thank you, Mr. Chairman. And I appreciate your response to that, Tanya. But it does give us this broad example that I think is kind of important at this point as we work through this, of that there can be ways, and again, sometimes it will depend on if it's challenged, but if it's challenged, there's also some different interests to be weighed. So for example, the absolute control provision that's in the Wyoming Constitution. If the legislature goes this direction and begins to decide we do want to provide some resources through education savings accounts for private schools, then we face some long precedent back to the 1920s of the US Supreme Court concerning the clear rights of parents to direct education, and whether or not that comes in conflict, if we're going to go this direction, to over-regulate, if you will. And I'm going to get more of that with regard to an amendment later, but we do kind of then, that introduces another idea outside of the Wyoming Constitution that might have an impact on whether or not the provisions about absolute control conflicts with the idea of the parental control that the US Supreme Court has many, many cases on. And so I just guess, again, I'm just trying to get this feel for the space we're in, and that there are different interests at play. And if we go this direction, it can get a little fuzzy, and we enter into different spaces with each step, so legally speaking. So again, I'd just like your comment on that. And then I have
Okay.
a question.
Mr. Chairman, Representative Lally, you're certainly correct that it's a balancing act, and where that policy line is for you all to decide. And I can't predict what the Wyoming Supreme Court would do. I can tell you in other states, some of these mechanisms like testing or an insurance that there's a basic educational program provided have assisted to sort of tie an appropriate use and benefit to the state in expenditure of those dollars. And so it's not, I mean, even in the public school context, the public school sector has quite a bit of control over everyday activities of students. And these are state funds. And so to have some limitation or some requirement in response for acceptance of those, I don't think is unreasonable. And I think it probably helps it look less like a donation and more like a service being provided to the state to better educate children.
Yeah. So again, a matter of balancing some of those interests and going too far, not doing enough. And I think we'd agree that's probably where we're going to be. And we'll talk more about that when we get a chance of amending. But I appreciate that. And again, if you want to let Senator Rothfuss had a follow-up. Oh, all right. But then I have another question.
Senator Rothfuss, go ahead.
Thank you, Mr. Chairman. And I was just following up on the representative's discussion on St. Stephen's. That portion of statute, I don't believe, has been reviewed by the Wyoming Supreme Court. I just wanted to confirm that there weren't any cases that related to that.
Mr. Chairman, Senator, that's correct.
Thanks.
Anybody on this end got a question down here? Go ahead, Representative Clauston.
Thank you, Mr. Chairman. Just some quick comments and then a question. So recently I got to go to the Education Convention of States, and this was a hot topic. Spent hours there, and they had a section called Lessons Learned on school vouchers. So advice was put a limit on it because otherwise things go over. So that was great. The percentage of poverty was brought up. In Wyoming, free and reduced lunch to qualify, it's $55,500 for a family of four. So right now we're sitting at $75,000, whether we think that's the right amount or not. They did talk about it bleeds students from our rural schools, so something to consider there. And then the accountability piece, some of the states weren't testing until 6th grade. So these students had been getting vouchers for a few years, and their testing, especially in math, was way behind their counterparts. So the suggestion there was we need some part of accountability every year, especially with the state funds. My question here is, I guess, I do see this as growing government. We're going to have to add some employees to run this. Do you really think 2 people in the Department of Education is enough to keep tabs on all of these vouchers?
Mr. Speaker, please go ahead.
So, Mr. Chairman, I just put 2 and XXX as a placeholder. Obviously, Mr. Chairman, when WDE gets up here, they should weigh in. They've been asked to weigh in on that issue. I don't know when they'll have that available for you, but I have asked for that through staff. So no, it's a placeholder, no idea.
Go ahead, Representative Lawley.
Thank you, Mr. Chairman. I wanted to ask you a question about page 3, lines 22 to 23, and then actually on to page 4, that section on qualified school definition, and kind of again following up on this idea of that balance that we're trying to reach about some accountability versus not interfering or infringing on parents' right to direct the education of their children, which is a constitutional right according to the Supreme Court. I see this certification process. I'm not sure how you're envisioning it, and would it be developed through rulemaking? Because I do see it as an opportunity to also provide some oversight from those providers about, history of their own history of success, graduating, college, all those kind of statistics, as well as really some other things that the superintendent of public instruction would like to see. So I see some here, possibilities, but I didn't know if that's what you guys envisioned or not, because I think that will relate later again to an amendment concerning the testing and what kind of testing is appropriate and fits in with this balancing, so.
Go ahead, Speaker Summers.
Mr. Chairman, thank you. So as you can see in that definition, it refers back to 212906A. And 212906 gives the superintendent of public instruction the task of establishing a certification process, which would be by rule, and it's intentionally vague other than the subject matter, with the idea that that can be worked out in, rulemaking is a public process, and it will give the public the opportunity to weigh in with stakeholders. And I would assume the superintendent will create something that's appropriate, rather than list everything that needs to be certified. I wanted to make that broad so it wasn't too constraining, into your point.
Thank you, Mr. Chairman. Would you agree, though, that generally speaking, that certification process does provide also some level of accountability in the process? I think that's the point I'm trying to get at. I understand about the rulemaking and, again, how it would be developed, but do you see it? I mean, is that the purpose of doing the certification, in fact?
Mr. Chairman. Mr. Chairman, thank you. And yes, that's why I put it in there, was accountability. Some other states have required certification in their processes. I thought it made sense to make this bill more constitutional, frankly.
Thank you, Mr. Chairman. On accountability and doing the audits in the bill, I see that we're asking for an auditing process, making sure that money is spent the way it's supposed to be. But is there any consequence to that? Is there follow-up if someone violates those rules in receiving these ESAs?
Go ahead. Ms. Heitrick.
Mr. Chairman, Representative, if you'll note, they're following that provision on page 18, lines 14 through 17. That's the provision that you're talking about, the 20% of the audit. And I think sort of in concert with that is the provisions that require that the state superintendent investigate reports of intentional and substantial misuse of educational savings account funds, and then prohibit those parents or those students or those educational service providers from participating in the program or from providing services. And there are, sort of a laundry list of items. They're listed on the rest of page 18 and on to page 19.
Go ahead, follow up.
Yeah, thank you, Mr. Chairman. So I guess with the $3,000, are we looking then we give it in chunks of money so that we would then stop payment beforehand? If a school requires funding to be brought, they want a $3,000 down payment or whatever holding, and we give them that full amount and it's misused, what happens?
Go ahead, Ms. Heitrick.
Mr. Chairman, Representative Provenza, you raise a great point about sort of a I think what you're kind of alluding to is a clawback provision. And there are provisions that, yes, I guess in direct response to your questions, it's 4 quarterly payments, so $750. But there are provisions in the Act that authorize sort of a prepayment to hold someone's spot, so to speak. And it speaks to the reduction of future payments, but it doesn't speak to any event sort of a clawback provision. I don't believe that the bill addresses that.
Further questions? Go ahead, Representative Provenza.
Thank you, Mr. Chairman. I know we were trying to get around with the poverty level and trying to figure out how we can give this money out constitutionally without directly giving to the schools. So I guess I'm wondering from your perspective, from LSO's perspective, when we're looking on page 17 and it says on line 13, the payment system shall provide maximum flexibility to parents by facilitating direct payments to education service providers, as well as requests for pre-approval of and reimbursements for qualifying expenses. So are we allowing for them to maybe skirt like give the payment to that school directly in any point? Or allowing the department to say that we can send those payments there?
Go ahead, Ms. Heitrick.
Mr. Chairman, Representative Provenza, I think sort of a high level review of the program is that these educational savings accounts will be maintained by, say, a bank, and the state treasurer will pay based on what the state superintendent identifies as, whether it's $750 or whatever that amount is quarterly, and then that amount will be paid to the bank. And the student will, I know in other states, they've given them the opportunity for a debit card, or they've given them the opportunity to just seamlessly transfer funds from that account to a service provider. But the educational savings account itself is held by the student.
Go ahead, Mr. Speaker.
So, Mr. Chairman, this is language from those original bills. And really that sentence doesn't frankly say a lot, in my opinion, because it says the payment system shall provide maximum flexibility to parents, and then it tells you how it'll do it by facilitating. So it's really not providing any direction other than, I suppose, it's providing some transparency to what what they believe, the original authors believe the bill does. So, I mean, unless somebody else can tell me that's kind of a fluffy sentence.
Go ahead. Representative Andrew.
Mr. Chairman, I can explain how that was intended to work originally if
Sure, go right ahead.
like. I mean, the original intent of the bill was either to have the money directly transferred to an education service provider by the direction of the parent. And the whole intent of that was so that they never had a chance to spend the money on something fraudulent. So there was either that way where education service providers basically set up an agreement with a third-party service provider so that the money could be transferred directly to them. Or there was also a system which more applied to people doing a home-based program, usually where it could be a reimbursement, and that would usually be for small transactions. You'd have to bring proof of, I purchased this and now I need a reimbursement for that cost. Thank you, Mr. Chairman.
Thank you.
Thanks, Mr. Chairman. I did just have a couple of questions, kind of reading through and thinking of how this would play out. The first is with regard to the 250% federal poverty level. It's kind of a hard line of 250%. One potential concern is that you end up with cliff effects. And I was wondering if there was any thought given to maybe some type of phase in or something along those lines, with the idea that imagine a family of 6 where the federal poverty level at 250% is about 100K of revenue. If you have 4 kids with vouchers, that's about 12K of value that you have. And you can imagine a circumstance where you make that $101,000 and you've just lost $12,000 worth of pre-tax value. You can have the unintended consequence then of actually trying to keep your income low, which I don't think is intended. So the thought there is, was there any discussion or contemplation of maybe some type of non-cliff effect, phased in approach to the federal poverty level?
Go ahead, Mr. Summers.
Mr. Chairman, no. I hear what you're saying, but I didn't try to devise. I've heard of that, like that concept, but I didn't try to do a phase in. I do think that, in hindsight, I would probably have went to 300% of federal poverty level. But no, I hear you, There's cliff effects in every funding system we've created in the state.
Yeah.
And yeah, that's a big one, but
But Mr. Chairman, with the possibility of increasing it, I mean, imagine a circumstance where it went to $6,000. You'd have a $25,000 pre-tax value up against a $100,000 revenue. And I do think that might be something to consider if the bill moves forward and understand that. Mr. Chairman, a second question that I have, which isn't clear to me in the way the legislation is drafted, is where the funds would reside, what type of an account would it be in? It seems to me like it would end up in agency pool as currently structured. This newly created account, is that where the account would reside as drafted?
Mr. Chairman, Senator Rothfuss, so the expenditure account is simply to hold the $40 million, and then paid from that account would be the educational savings account certified by the state superintendent. And in other states that we looked at, it's generally a bank that the state superintendent or the entity contracts with, and they actually hold whatever that amount is that's certified by the state superintendent on behalf of those individual students.
Good. Mike.
Thank you, Mr. Chairman. And Mr. Chairman, I meant the $40 million account specifically where it would reside, because if the intent is to generate revenue off of it to maintain funding similar to what we do with the Hathaway, it seems to me that as the legislation is currently structured, you'd be getting your 2%, when I would expect you'd want 5 to 8%. So I was curious if I'm misreading that, or it looks like it ends up in the agency pool as drafted.
Mr. Chairman, Senator Rothfuss, I can't answer that. I structured this language on the expenditure account similar to the Hathaway and the other scholarship programs that we have utilized. Perhaps Mr. Wilmarth has a more definitive answer.
Go ahead, Mr. Wilmarth.
Mr. Chairman and Senator Office, I think it's going to be a determination by the treasurer and how much demand there is for this program. You know, they'll allocate the funds to each of their investment pools based upon how much is certified by the superintendent.
Mr. Chairman, I thought we had to explicitly say something was going to go to Pool A or a higher investment yield account, even a portion of it in statute, make it eligible for that, for it to have the authority to be invested that way. And I believe we would have to explicitly say that for that to take place.
Mr. Wilmarth?
Mr. Chairman, Senator Office, I'll have to take a look at that. And I think there are certain thresholds, like a 2/3 vote requirement to invest in equities. I believe that's the requirement. So, Mr. Chairman, I can certainly research what the requirement is if we need to specify that or not.
Okay, thank you. Mr. Chairman, another question for the speaker. As structured, there is a set amount of value and there's an indeterminate number of applicants that would come in. So you'd have some number N of applicants times 3,000. But there doesn't seem to be an up to phrase. It seems to be a set phrase. So I see a circumstance where you could fall short on available funding based on the revenue off of the endowment model concept. And there doesn't seem to be a way to provide flexibility to underfund or limit funding. Am I missing something there? There was a rule mentioned earlier, but I don't know if the flexibility exists as this is structured to have a rule that would allow for a partial funding or a more restrictive list of who is eligible.
Go ahead, Ms. Heitrick.
Mr. Chairman, Senator Rothfuss, if you look on page 13, lines 21 through 23, and then on to page 14, lines 1 through 3, it's a first come, first serve basis. So to your point, it would be those that, apply first, sort of get the eligibility.
Great, go ahead. Mr. Speaker, go ahead.
Mr. Chairman, thank you. And on that note, I looked at, fill up the bucket from the bottom first, take the poorest child and then work your way up until you run out of money. But that is a fairly complicated structure and statute, so I didn't go down that path, but I did think of that path.
Go ahead, Senator Rothfuss.
Thank you. And that bottom of page 13 certainly answers that last question. So I appreciate that that's been contemplated. And the last question I have gets to the eligibility concept, which is mentioned in the memo a little bit, about not just for service of the poor, but the secular nature of educational funding and whether funds can go to a religious institution. For educational funds, it makes it very clear that it can't directly go to a religious institution. I was curious of how this addresses the idea that indirectly that would probably be the outcome. My expectation is that religious schools and religious private institutions appear eligible based on my read of this. So how do we get to the point where that is not a constitutional violation of the Wyoming Constitution specifically, whether it is or not at the federal level?
So whether it is or not will be up to a court, but the cases, and I'm not a lawyer and haven't reviewed all the cases, but the cases where states have provided money to private schools, it's been found basically discriminatory to not allow that to go to a religious school. So my opinion is if the basic structure stands that we're providing money to a private school and that can hold, then I think it probably holds on the side of whether we can put money towards a religious school. But that'll be the courts unless Tanya might have something, but that was my thought.
Mr. Chairman, Senator Rothfuss, I mean, that is sort of the crux of the legal issue with this bill. There are a number of issues that the speaker addressed, the federal poverty level, the requirements for the education, the certification, those types of things. But the basic question of those constitutional provisions and expenditure of funds that will indirectly, result in funds being transferred to private and religious schools, we can't answer that question. There are two recent Supreme Court cases on school voucher provisions, and they both sort of dealt with this issue, but they were analyzed under the free exercise clause, which I would point out, and sort of what our takeaway from those cases is that a state need not subsidize private education, but once a state decides to do so, it cannot disqualify some private schools solely on the basis that they are religious.
Okay, one more quick follow-up.
Yeah, on that point, and I'm familiar with that decision, the recent U.S. Supreme Court decision. My concern, though, is the idea that what that says is if funds are given to private schools, they cannot be discriminating based on whether they're religious or secular private schools. I guess I'm curious for analysis that would say that the Wyoming Supreme Court would not make all of that unconstitutional based on the idea that the Wyoming Constitution explicitly makes it unconstitutional to provide funds to a religious school. And if you have to have equivalency, if you have an inherently unconstitutional action and another action that has to be equal to it that's constitutional, so you've got 50% unconstitutional, I don't know why the Supreme Court would then rule, well, if it's only 50% unconstitutional, we'll call it constitutional. I guess I would be surprised that would be a state ruling in that circumstance, because the equivalency has to be there, and I agree the equivalency has to be there by the federal rule. My concern is if it's deemed unconstitutional clearly by the Wyoming Constitution, would we not expect the Wyoming Supreme Court to say, well, I'm sorry, you can't do this program at all, whether it's a private secular school or a private religious school?
Mr. Chairman.
Go ahead.
Mr. Chairman, I'm not a Supreme Court justice in the state of Wyoming, so I'll let them decide that.
Okay, thank you.
The only point I would make, Mr. Chairman and Senator Rothfuss, is if you look at the memo, which I will note for the record was released by the chairman, so it is a matter of public record, on page 3, there's sort of this notion that you get to that the exception for the necessary support of the poor contained in Article 16, Section 6 does not swallow the prohibitions contained in Article 1, Section 19, and Article 3, Section 36, meaning a claim that the recipient of a legislative appropriation is poor does not render the other provisions of the Wyoming Constitution void. And that was the state of Wyoming versus Carter.
Representative Brown, you have a question.
Thank you, Mr. Chairman, and I appreciate the questions from our good senator and some good information here. Mr. Speaker, my question directly goes to this idea of the, excuse me, the 250%. You've mentioned 300%. Can you explain to me your logic on how that intertwines with our constitutional requirement of providing state funding to the needy and the poor? That, you know, I guess my look at this, as I see poverty becoming the needy and the poor, but then we extend that to 250 to 300%. We do similar things with Medicaid and those types of situations. So I'm just kind of curious if you can elaborate for the committee, maybe for the public as well, what your rationale behind taking this to 250%, your thoughts on the 300%, how that intertwines and how you see that as staying constitutional in your mind with providing funding to the needy and the poor.
Go ahead, Mr. Speaker.
So, Mr. Chairman, so when I first looked at the idea of, you know, federal poverty level and to try to draw a line where the line should be. I don't know whether 300 or 250% makes it constitutional, whether it does swallow or not swallow the other provisions. I think that's to be determined. I went to 250% for much of the same reason people have talked to me about the going from 3 to 6. 250% of federal poverty level picks up like a hole in the early childhood where we kind of have a need. And I would assume that same need exists maybe as we go into K-12 in private schools. So that's kind of why I chose that. I think 300 and 250 you'll have the same argument one way or the other. I don't know if staff has any comment on that or not, but yeah.
Mr. Chairman, Representative Brown, I mean, the memo also talks about this a little bit as well. There is no specific number for that constitutional provision, what is deemed necessary support, you know, of the poor. And obviously that would be, as the speaker pointed out, determination by the Wyoming Supreme Court, obviously first to you, and then if challenged to the Supreme Court. And there's no single case or attorney general's opinion which provides clear lines demarking poor versus non-poor and necessary versus non-necessary. Overall, it's sort of an evolving area of case law and generally very fact-specific determinations.
Representative Lawley.
Thank you, Mr. Chairman. I'd like to go back to Senator Rothfuss's series of questions concerning a conflict with state constitution versus US. And the way I want to do it is return to that case you referred to, a recent case 2020, I think it was June 30th, 2020, Espinoza versus the Montana Department of Revenue. Because I think some of the facts of that case are important for us to understand because it dealt with some Montana constitutional provisions that are similar to some provisions we have in our Wyoming Constitution. And it really does begin to unpack some of the questions that you raised. So I'd like to just kind of go over some things and then we can kind of wrestle with it a little bit. But because when I read the opinions, a couple things really caught my attention again about the parallels to Wyoming. And in general, the Tanya's memo well describes the outcome, if you will, of that case. Basically, what the court holding was in Espinoza was that the Montana state constitution's no aid to religious or sectarian schools provision discriminates against religion in violation of the free exercise clause of the First Amendment of the US Constitution. So here's kind of the facts of the Espinoza case is the Montana legislature created kind of a scholarship type program for students. And it did not in the actual enabling statute make a distinction between religious and secular private schools. It was for private school, help with private school tuition, somewhat like what we're doing here. So the legislature did not make that distinction, but the Department of Revenue for the state of Montana determined that they would not allow payments to religious schools. And that was litigated and it went to the Montana State Supreme Court, and the state Supreme Court chose to follow their constitutional provisions as a reason for not doing that. Again, something that could happen, I suppose, in Wyoming, but this was really the actual issue being litigated and it went to the Supreme Court. And one of the things that was important to me is understanding how the Supreme Court viewed those provisions of that Constitution. And the question, I think, for us to think about and consider is, would some of the Wyoming provisions be considered in the same way, or at least applied in the same type of situation in the same way? So again, if you'll bear with me, Mr. Chairman, I want to give a little, some quotes from the majority opinion was written by Chief Justice Roberts, but there was also a concurring opinion written by Justice Alito, which went into great detail about the history of these amendments, and that they're commonly referred to as Blaine or Little Blaine amendments, and I'll explain that in a minute, because it had a profound effect on the ruling of the court and why they went the direction they did and took the position they did. So the U.S. Supreme Court's majority opinion noted the troubling history of the Montana Constitution's no aid provisions. Justice Alito wrote a concurring opinion, again, as I said, to provide some more details about the history of the bigotry behind such provisions. According to Chief Justice Roberts' opinions in Espinoza, in 1875, an amendment to the U.S. Constitution prohibiting aid to Catholic and other sectarian schools was proposed by then Speaker of the U.S. House of Representatives named James Blaine. And it became called the Blaine Amendment. That Blaine Amendment to the U.S. Constitution failed. It failed in the Senate to even get out towards the states, and it was narrowly defeated. And again, quoting from Justice Alito's concurring opinion, he writes, and I quote, "Afterwards, most states adopted provisions like Montana's to achieve the same objective as at the state level, often as a condition of entering the Union. 38 states still have these Little Blaine amendments today," end of quote. Wyoming is one of those 38 states that still contains these Little Blaine amendments. We have a kind of a classic sort of Blaine amendment, and then we have that same language weaved into 5 of the 6 provisions we're looking at right now in the Constitution. So the majority opinion in Espinoza states, "The Blaine Amendment," and I quote, "the Blaine Amendment was born of bigotry and arose at a time of pervasive hostility towards the Catholic Church and Catholics in general. And its state's counterparts have a similar shameful pedigree." Justice Alito goes on in his concurring opinion that at the time, it was an open secret that sectarian was code for Catholic. The term was likewise used against Mormons and Jews. And I found this to be just myself. I read, believe it or not, kind of a nerd, and I read a lot of Supreme Court decisions. I listen to oral arguments from time to time on certain cases I'm interested in, but this was unusually strong language, both in the Roberts opinion, but particularly the Alito concurring opinion was specifically to address the history of the Blaine Amendment and why it was important in the decision. And so, as I said, 5 of the 6 constitutional provisions that are in the memo have and include some Blaine Amendment type language. So my kind of thing I've been wrestling with is, in light of the history of the Blaine Amendments, the U.S. Supreme Court's disdain for them and their potential to violate the U.S. Constitution's First Amendment free exercise clause, we have to kind of consider and think carefully about what the Wyoming Supreme Court might do in light of the Espinoza case, whether or not they would in fact say we can't give to religious groups. And so I just think it really begins to tell us that some of these provisions, particularly the Blaine Amendment ones, have some issues that are beyond the state constitution level. They go to the concerns of meeting the U.S. Constitution, which is Article 1, Section 27, we acknowledge that the Wyoming or the federal constitution is superior. That was already determined in case law a long time before Wyoming became a state, Marbury versus Madison. But basically, we adopted that idea. So again, to continue to look, because I think this is also an issue concerning how some of these provisions interact with parental rights and the Supreme Court decisions concerning that. So again, it points out the interplay. It gives us some understanding of how did this language end up in our Constitution, and whether or not it would be enforceable, or that the state would would choose to do that. So again, not directly on point. I'm not suggesting that but it is interesting that the legislature of Montana did not make this distinction. It was another agency that made it and created kind of the issue. So again, I just think that's important. I think it helps perhaps, Senator Rothfuss, for you to a little bit grasp what the issues were at the federal level concerning the Montana's provisions, which are somewhat similar to Wyoming's.
Thank you for the history lesson.
You're welcome.
Go ahead, Mr. Chairman.
Mr. Chairman, trying to bring us back to the subject of this bill. The advice we got, I believe it was last year, when we talked with school choice, from some of the private attorneys that were concerned, was that the way the Wyoming Constitution is written, the prohibition against using for either religious or the money for having school money go to private institutions in Article 7. The way it's written is that applies to the monies that are dedicated to the schools. And you look through Article 7, there's a series of that. The advice we got was that if you use general fund, which is not dedicated to schools, those prohibitions don't apply. The prohibitions in 16.6 and in Article 1 do apply, but we can work around them, and this bill and its predecessor, Senate File 1 or House Bill 194, has adopted the same solution, and that's to use general fund. Whether a court will buy that or not, I don't know. I don't think anybody can tell you. But that's the argument, and I think it is a credible argument. Again, the risks in a court decision. But this bill concentrates on using the general funds for that reason. And the workaround of how you appropriate the money so that it is appropriated to a state entity, I don't think the bill is perfect on that. I think we can fix that. So, Mr. Chairman, I think that's where we are. And it's going to be a matter of judgment as to how you think a court will rule on the constitutionality of the approach that these bills use.
Representative Berger, you have a question?
Yeah. Kind of staying on that, but switching gears. But my question is the general fund a public fund, Mr. Chairman?
Mr. Chairman.
Mr. Co-Chairman?
Go ahead, Mr. Co-Chairman.
It is, of course.
Okay.
They're all public funds.
Okay.
But when you read Article 7 carefully,
okay,
certain funds are dedicated to the schools. And there's an enumeration of them. We've added to them constitutionally with some constitutional provisions on mill levies that are dedicated to the schools. The general fund is not dedicated to the schools. It's the general fund.
Yeah.
And the argument is that the prohibitions on using school funds for non-public school purposes are specific to the school funds and do not apply to general fund appropriations.
But the general fund is a public fund.
Oh, yeah.
Okay.
And there's no question about that.
So my next question then, Mr. Chairman, and even to the speaker, is consumer protection. So if we're allocating $3,000, one, I think we're the consumer, the legislature or the state, and the fund is going to the child who is a consumer as well. And my example is that fund comes to me and I'm paying for my child to go to a private school, and it's $20,000 for tuition. And we pass this, and I'm thinking, oh, great, it's going to be $17,000 now. And how do we protect, or is there statutes to protect the consumer from that public school saying, or that private entity going, no, 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 now tuition's 23,000. And then we say, do we go to 6,000? And then they raise their cost to 26,000. And then we say, okay, let's help them out 10,000. Then they raise their, so how do we, is there statutes protecting the consumer? Because I think we're the consumer and those children are the consumer. Is that there, maybe Mr. Speaker, Mr. Co-Chairman? I don't know. And that's the question I'm thinking.
Mr. Speaker.
All right.
Mr. Chairman, thank you. And no, there's no provision to do that, just like there isn't with the Hathaway. And we've seen that happen with the Hathaway. That could happen in the private sector as well. So there's no provision.
So then, Mr. Chairman, sorry, I didn't mean, so.
Is there a question?
Yeah, the question is, do we do consumer protection inside this bill? Or do we write a separate bill for consumer protection?
We could put an amendment in if you'd like. I mean, we can float it and see what happens.
Okay.
You have an opinion? Go ahead. I'm sorry, Representative Andrews, go ahead.
Thank you, Mr. Chairman. I just have a question for the speaker. Mr. Speaker, on page 5, line 8 of the draft, there is a provision that essentially tips the funds back into the general fund if they're not going to be required. And this is, I think, leftover language from the foundation bill where it used FMR funding and there was a automatic flow of revenue into the account. But my understanding of this is that we need to appropriate money from the general fund into this account. And I'm wondering if it would be a friendly amendment to just remove page 5, lines 8 through 16, so that there's no automatic tip back and the legislature can just make that appropriation if they deem necessary.
Mr. Chairman.
Go ahead, Mr. Speaker.
Mr. Chairman, the clip in the tip doesn't bother me. So no, I think that'd be fine.
Chairman Scott, you have a question?
Chairman, okay. This looks to me like standard boilerplate that puts excess funds back to the general fund. I think it's harmless.
Senator Rothfuss, go ahead.
Thanks, Mr. Chairman. I think if you're supporting the legislation, you're supporting the program. I think Representative Andrew is exactly right. I think you need to contemplate future expenditure increases and the traditional structure we do when you actually want to account for future cost increases and future number increases is to make sure that you're bringing the additional revenue back into the corpus and that corpus grows over time. And this is not an inviolate corpus, so you'd be able to deappropriate if it grew too much. But it does seem that I think Representative Andrews is correct in his analysis that as a proponent of the program, I would want that if I were you.
Representative Andrew, go ahead.
Mr. Chairman, Mr. Speaker, I have one more question about some language that was removed. That was in the foundation bill as well, that having a little trouble with why it was removed. There's 3 sentences in various parts of the bill. One of them is, no parent shall be required to include any instruction that conflicts with the parents or the ESA students' religious doctrines. Another is, nothing in this act shall be construed to expand the regulatory authority of the state, its officers, or any school district to impose any additional regulation of education service providers beyond those necessary to enforce the requirements of the ESA program. And the third is, an education service provider shall not be required to alter its creed, practices, admission, policy, or curriculum to accept payments authorized by a parent from the ESA. All 3 of those sentences were in the foundation bill and were taken out in this draft. And maybe you could argue that they don't need to be there, but I think they're very important sentences that explain and just solidify that we're not trying to take any of the autonomy from private schools. We're not trying to violate anyone's religious freedoms, and I do not think that that was your intent whatsoever. And I'm wondering if it would be a friendly amendment just to place those sentences back in the bill where they were.
So, Mr. Chairman, yeah, I took them out because I think it was superfluous language. I don't think they were necessary. You know, if you all think they're necessary, that's up to you all to decide. You know, I'm not, I don't think they help or harm the bill, personally.
Well, I'd like to hear from the department and kind of work towards getting public comment. So could WDE step up and give us your impressions on the bill, please? Thank you, Mr. Speaker. Thank you, Tan.
Thank you, Mr. Chairman. To speak on behalf of Superintendent Degenfelder, she does support the concept of ESAs and wanted me to share just a couple comments related to this current draft. And first of all, she wanted me to thank the speaker for bringing this forward and this committee for hearing this today. She thinks it's an important tool to advance school choice in our state. One key central thing to be considered is the amount that's been put in there for the account, the $3,000. National standard for that is something much more comparable to what the per pupil expenditure would be in K-12. And for example, if you look at Arkansas's recent ESA bill, they did 90% of the per pupil expenditure amount in the state. Iowa did 100%. So I think we really need to look at that $3,000 amount and get it closer to what the per pupil expenditure is, because the consequence of not doing that is providing almost a false option, because if it's not enough, no one's going to use it, and then the program will be determined to be a failure, et cetera. Second is, I know there are some constitutional issues that have been discussed, but she did want me to share that while an income requirement may make more sense at the pre-K level, she did not support an income requirement at the K-12. She thought it should be available to everybody. And then last, there was some discussion earlier about the FTEs and the potential of a vendor. We're actually meeting with the preeminent vendor that does these ESAs tomorrow to really understand what we would use them for, how much it's going to cost. But we would anticipate significant 900 series being needed to get the outside vendor support that we need to run a program of this magnitude. The 2 FTEs at this point doesn't seem unreasonable. It seems like it may be adequate, but the 900 series would be a big piece of the puzzle.
Questions for Dickey? Go ahead, Senator Rothfuss.
Thank you, Mr. Chairman. The first question, getting to the last point, Mr. Shaner, the significant 900 series, what is the cost that other states are experiencing? You mentioned that we've got others that we can take a look at. What will the ultimate cost be if we were to fully implement it pursuant to the vision of the superintendent on an annual basis?
Thank you, Mr. Chairman. Through you, Senator Rothfuss. I don't know that number yet, but when we meet with the vendor tomorrow that's working with other states, I'm hoping to get a good understanding of what those other states are paying them to do it. Obviously, it'll be a little smaller scale for us, but we should have a good idea from them soon.
Mr. Chairman.
Go ahead.
Right now, as structured, then there's funds available for 2 FTEs, but there isn't a significant, there's no way for the department, for example, to tap the revenue stream that comes off of the $40 million endowment. So where would you anticipate the funding come from for the 900 series? Would that be something that you would submit through your standard budget, or would that be something where you would expect a change to the way this is structured, where it would come off of the top of the $40 million endowment revenue?
Mr. Chairman, through you, Senator, I think either way could work.
Further questions for Mr. Shaner? Okay, thank you. We'll open it up to public comment. I remind everybody that it's going to be 5 minutes per comment, and please fill the chairs so that we can move right along. State your name, please, and
Mr. Chairman,
Go
Mr.
ahead.
Co-Chair, Committee, I'm Sue Wilson. Many of you know me. I spent 10 years down in the basements here. Some of you are new. I'm retired after 10 years in the legislature. I did run 2 bills regarding school choice when I was in. I'm not a lobbyist. I'm not being paid to be here. I'm here on my own dime, but I stay involved with some school choice options. Mr. Chairman, with respect to your 5 minutes, I'm going to try to condense. Obviously, after 10 years of reading bills, after reading a 29-page bill, I had a lot more than 5 minutes for it to say, but I will condense. And as a matter of fact, what I think I would like to do is mainly address a couple of the questions that came up. And so I'm going to take my comments out of order. But the first question about the preschool component, I'm not really sure. We heard about a lot when I was on the Labor Committee, which committee is where I spent most of my life. But we do have an existing child care assistance program. It's funded through DFS, and it's basically from federal block grant. And if you all want to look that up, it's under DFS. It's on page 80 of the DFS budget book. So they're spending $12 million a year for 2,838 children at the most current budget bill. So it wasn't clear to me at all from this bill whether that program was even being considered or how that would integrate in. They're getting an average of $4,200 in subsidy for low-income families. So are we really thinking of adding $3,000 on top of the $4,200? That seems pretty significant. You know, DFS does license the preschool type childcare providers. As far as I know, there's no differentiation in licensing between just a daycare and some sort of, literacy-based pre-K type thing. So I don't know that that can be defined. So I think you need to really consider, was that just not realized that we do that? So that would be a lot of kids, and as I say, they're already spending a lot of money there, and it's mostly federal funds. Now, I will just say that program, regarding Representative Brown's question about the poverty level, that program, as far as I can understand it from the budget book, goes up to 225% of the federal poverty level, so that is fairly parallel. But I just want to bring up that preschool part, because I think that, frankly, to my mind, this program would be duplicative, and we're not really trying to supplant the federal funds, I don't think, that there's a whole ball there. So I put that one in there. I do want to say, although I'm not a lobbyist, I've started, I have a newsletter that goes out to private schools in the state, so I'm going to try to provide you folks with some numbers. The number of students is not really that big. I think there are about 50 K-12 students or schools, in the state of various kinds. And really, they only average about 50 students per school. There are very few schools that have in the 100 range. Maybe 3 or 4 in the whole state, something like that. So, even if you had every student in every school eligible, which is obviously not the case, that's like 2,500 students. But so, this program is only talking about maybe 1% of the student body of that age group across the whole state. And as a matter of fact, regarding the 50-50 allocation that was in the bill, the 2,800 current children in the child care assistance program, that's probably about maybe 5 times as many students as are currently in the K-12 private school system. So I just wanted to give you the numbers on that. As far as the median tuition in Wyoming, and I'm using the median because the schools in Teton County are a lot more, about 5 times more expensive than the average. But most of the other schools, the median is about $4,000 a year. So I have to say, as far as what other states do, and I know, many of us have friends back east who are paying astonishing sums of money to send their children to private school. That's really not the case here in Wyoming. So if we had an ESA, and again, I just want to say, I'm not speaking for the private schools. I don't know who's on Zoom looking and thinking, what is Sue saying? Okay, this
430.
it's just me. Anyway, about $4,000 average, excluding the Jackson schools. I would also then, the fourth thing I'll just throw in, and if I'll be glad to take questions, but as far as the certification process, just picking up on page 15 on line 16, I do want to remind or point out that under 212406, licensing is not required for schools that are maintained by a church or a denomination or religious organization. Many of those schools do go through the licensing process anyway, but it's not required. And also the definition of basic academic education program and statute, that's in 214101, A6. There's a specificity in there on how that applies to private schools and clarifies that the state can't require them to go against their religious beliefs. I would recommend inserting a clause into the page 15 paragraph, subjecting that to the exemptions and definitions in those statutes.
Thank you.
Thank
Sue.
you, Mr.
All right. Any questions for Ms. Wilson? Okay, please proceed.
Hello.
Hi.
My name is Leslie Heiner. I'm legal counsel for EdChoice. We're a national foundation. We've been around since 1996. We are educational only in nature. Our mission is to educate people about educational opportunities and how to provide those and how to fund those. And as the lawyer in the group, also to help you think through the legal challenges and issues that you face. So it occurs to me that, well, first I should say, I'll be here for 2 days. 5 minutes is a long time to put almost 40 years of experience, which is what I have advocating for school choice, before you. But I want to make myself available to you. There are certain key legal points that I think are getting a little bit mixed, and I think it will help you a great deal to not mix the legal points. First of all, ESAs do not fund schools. In fact, no school choice program ever funds a school. That is a paramount principle of school choice. And in fact, when this was challenged over the Cleveland Vatcher case back in 2002, that also went up to the US Supreme Court, and US Supreme Court was very specific about this. These programs allow parents to direct the funding of the money that the legislature has appropriated for a child's education. This does not go to schools from the state. The parents decide whether or not they want to participate in this program. And if they do, and especially under an ESA, there's really no requirement for the parent to use that funding at a school for tuition. We're seeing across the country now, many parents are getting together, maybe 3 families. They may hire a couple teachers instead of paying tuition at a school. So clearly this is not a case of funding schools. I'd like to emphasize this point also because there is a case that we expect to go to the US Supreme Court soon in the state of Oklahoma, where they have enacted the ability for charter schools to be private religious schools. The question on the table is whether or not the state can directly fund a private school. This is a case of first impression. This has not occurred previously. This will be a first-time case for the US Supreme Court to handle. So again, I emphasize this program does not fund schools. There is a right to education here in Wyoming, and I think what's really significant about this is who holds that right. It's not the public school system that holds that right. It's the citizens of the state that hold this right on behalf of their children. And so you as legislators, you have the obligation to fully fund your public school system. And I have to say, in looking at the numbers, I think you've done a rather great job of that to really pay attention to public school funding over the years. Now, at that point, when everyone agrees that you have met that constitutional obligation to fully fund your public schools, you could stop and say, we've met our obligation and we're done now. However, that would be greatly adverse to the very strong tradition and proud history of this state, even prior to statehood, of emphasizing educating all children. Every year you have well over 1,000 children who drop out of the system altogether. Even though you are supplying the basket of goods, you are supplying adequate public education, there are still many children who do not learn under that system. And there can be a whole variety of reasons why that happens. But you have before you then the question, do you let that go? Or do you recognize that those 1,000 children and maybe many others who are not yet learning in your public schools, they also have a right to the opportunity for education under Article 1, Section 7 of your Constitution. It's very clear. And so I commend you, first of all, for bringing this legislation, because clearly you're saying we're not done. We do recognize that every child, and whether it is a billionaire's child or a homeless child, but a child who is a citizen of this state deserves your notice and attention and your funding for education.
Thank you.
And again, I'll be around. I brought all my books about Wyoming. I've been doing a lot of research, and I have to say, I love it too. It's great history. Thank you.
Thank you, Ms. Heiner.
Any
Do
questions?
you have a question? Go ahead, Co-Chairman Scott.
Mr. Chairman, and I'm trying to get my mind around what you were just talking about in terms of the right to the education being with the child and with the parents, as opposed to the institutions of the public school system. A couple of things. In the bill, there's a provision for they have to take the assessment tests. Is that important in terms of making this a workable constitutional system? Second, does the state have an obligation where the public schools, although very well funded, appear to be in part failing independent of the funding, to look at some of these alternatives? And maybe just elaborate a little bit on what the implications of that right to the child and the parents to the education are.
Go ahead, Ms. Heiner.
Thank you. The right to education, and as it relates to the assessments, the testing, I can tell you that over, going on 40 years of this now, there are some states where they have figured out a testing regimen that seems to work for them. And in most cases, it allows for flexibility of testing. In my home state of Indiana, our private schools adopted the state test, wanted to be state tested long before we had vouchers, because they wanted to prove to everybody that they were really good schools. And at that time, people thought they were really bad schools, but they weren't. So they decided to take the state test. They rue the day that they did that today, and they would not recommend that to anyone. And the reason is simply this, that, and even in your public schools, leadership matters. And so the leaders in these schools will direct how the curriculum is taught. And most specifically, let me affirm, when I talk about the leaders, I'm talking about the teachers in these schools. They're going to adopt their teaching methodology to do the best they can to reach these kids. Well, sometimes that methodology aligns nicely with the state test, and other times it doesn't at all. There are times when, especially in private schools, you may have students who you may have a whole class of kids who are doing really exceptionally well in math, and they need to keep going forward. They may be in 8th grade, but they need to be doing 10th grade math because that's where they are. Well, if you're testing on something else that they did a couple years ago, the kids get confused. It doesn't work very well. And so there are other tests that are available, some very good. The teachers love the Northwest Evaluative Test in particular. It's a good diagnostic tool. And they can use that kind of testing in a very individual way to both individual children, individual classrooms, et cetera. So, for my money, I'd give the teachers in the school the flexibility on the testing piece so that it accurately reflects exactly what's happening in that school and to those children.
Further questions from the committee? Thank you, Ms. Heiner.
Thank you.
Good, you're next.
I'm just a mother of 5 kids. I live in Casper, and
Your
I
name?
have Mary Schmidt, and
Thank
I
you,
have
Mary.
homeschooled, private schooled, and public school. A point of an ESA account is to give a parent choice in education. As this bill is written, I wouldn't waste your time. You won't have people participating, as you guys have all clearly stated that you can't support a religious school, so that eliminates anybody else who's going to enter into this program in the state of Wyoming, because we only have religious schools outside of a public school. You've eliminated homeschoolers. They're not listed anywhere in the bill, not that they would join as written anyways. So I wouldn't waste your time. Just get rid of it. If you do choose to continue, then I make the following suggestions. Testing, dump it. No private school in this, or at least that I know of in Casper, will go ahead and do the testing. That will be on the onus of the parent. So they won't participate in it. They don't do it now. Why would they do it then? Secondly, you do not need to provide the full amount of the education of a private school or a homeschool reimbursement to a parent. They need to have buy-in. $3,000 is enough. Make the parent pay the rest. Then that way they will always have buy-in and choice and take the money. Secondly, the Wyoming Constitution says we do not have to have our children educated until the age of 7 to the end of their 16th year. So that is the only time that you guys need to provide an ESA account for. After that, parents are on their own. Secondly, income requirement. The state of Wyoming does not allow a billionaire to not educate his children because he's a billionaire. So therefore, you need to provide this for every family that has children of school age requirements. Otherwise, you're violating their rights to an education. So you can't pick and choose based off of income. It doesn't matter. Every child is equally entitled to an education, period. If you really have an issue, look at the Hathaway Scholarship. There's not income requirements to that. You have to have, it's a merit-based. You have to have an ACT score, you have to have a GPA. You have 3 options based in that category. There is a income I think, stipulation to it, but every student who graduates from a Wyoming high school gets an option to it. And if you need to run this, run it through that organization. It's simple. You guys do not need to make this that complicated. As far as a religious institution, if you're only offering $3,000 to a private school that costs $5,000, you're not providing the full amount of the religious education. You're only providing the amount for those academic subjects that are non-religious. So the remaining balance that the parents have to come up with covers the religious component. Therefore, you're not violating any of the Constitution or the statutes. This does not have to be complicated. You just need to involve parents who are involved in an education system, not anybody else. They're the ones that know the options they want. And you need to make this as open-ended as possible, because private education, public education are not the only options. And if you really want to give parents choice, then give them the full choice. Homeschooling, private schooling, public schooling, charter schooling, open it up, because children do not all get educated in the same way. And you guys in this bill are controlling the education system as much as you control the public education system. So why would anybody buy into it if they're not happy with the current situation? Thank you.
Thank you. Questions for Mary? Thank you, Mary. Go ahead, please.
Good morning, Chairman and members of the committee. My name is Jill Cavanero, Director of Government Relations at Class Wallet. There's been a few questions this morning about actual facilitation of payments in an ESA program, so thanks for the opportunity this morning to briefly share how digital wallet technology has swiftly become the most effective and efficient tool for, one, empowering families to direct their ESA funds without ever having to come out of pocket, two, eliminating fraud, waste, and abuse of ESA funds, and thirdly, streamlining the administration of ESA funds with dynamic spending guardrails, data transparency, and spending tools. Class Wallet was founded in 2014 with an initial goal to create a simple technology that would allow teachers to get the funds they needed for their classroom and spend them in a streamlined way. In 2018, we adapted the technology to serve ESA families in North Carolina. Class Wallet is now the country's leading digital wallet service provider, partnering with state agencies and scholarship funding organizations in 5 states: North Carolina, Arizona, Indiana, New Hampshire, and Missouri. In addition, Arkansas ESA families will use Class Wallet when that program launches later this month. In total, Class Wallet has securely facilitated more than $750 million in ESA funds to over 60,000 families since 2019. I'll briefly share more details about the 3 key ways digital wallet technology is enabling and safeguarding ESA programs through a cashless disbursement of funds. First, digital wallets empower families to direct their ESA funds without ever coming out of pocket for the expenses first. Families are given a login to see a digital representation of their account balance, but never have access to cash. They can access a marketplace of e-commerce retail vendors, shop those vendors' websites in a way that aesthetically looks and feels exactly the same as if you or I shopped those websites online. However, when that family clicks checkout, it takes them back to Class Wallet for payment. Local vendors such as private schools, therapists, etc., they can also be loaded onto the Class Wallet platform. The family receives an invoice from that service provider, uploads a copy of the invoice onto Class Wallet, and Class Wallet facilitates the payment on over to the provider from the digital wallet balance. Secondly, digital wallets virtually eliminate fraud, waste, and abuse of ESA funds. When families make a purchase or spending request, as I just described, the transaction is not immediately processed. Instead, it goes into an approval queue for an administrator to review. This means not a single dollar needs to leave the platform without human eyes verifying it first. We have many features built in to make this process quicker for administrators, including batch approvals and custom curated vendor shopping pages, just to name a few. Taking it even further, families are only able to direct funds to vendors on the platform who have been pre-approved by the program manager. As an additional measure of fraud protection, goods purchased on the platform cannot be returned directly by the family, as they won't hold an actual store receipt. Instead, they have to work through Class Wallet to return the item, and the balance gets returned to their Class Wallet digital wallet balance. Finally, digital wallets streamline the administration of ESA programs with dynamic spending guardrails, data transparency, and reporting tools. ESA administrators love their digital wallets for many reasons. Imagine having to read a cash register receipt that was low on ink and only shows up to a 16-character description of the item. It's barely legible, and the way the store abbreviated that Chromebook into 16 characters makes no sense. The funds have already been expended, and maybe what the family ended up purchasing doesn't turn out to be an allowable expense. Now that program administrator is going to have a tough conversation with that ESA parent. However, now envision that transaction took place all electronically. The family requests the purchase online, the request goes into an approval queue, the program administrator reviews the request and can see a full product description. For example, HP Chromebook, 14-inch, Intel Celeron processor, 4 gig memory, Chrome OS. The administrator can also look back and confirm that a laptop has not already been purchased for that student this year. Once verified, the administrator can go ahead and approve the transaction, and the product will now ship. On the other hand, maybe the family tried to purchase a laptop that was over the spending limits per the program rules, and therefore the administrator has the opportunity to recheck the transaction and give a detailed explanation before any funds are actually expended.
4:30.
Thank you. In either case, all the details, including that SKU level data description, are available in instant audit-ready reporting with custom categorizations. This means requests for spending data can be quickly fulfilled and broken down into categories like those in the draft bill: tuition and fees, tutoring, textbooks and curriculum, technology, exam fees, and the list can go on. This is just a high-level summary of the ways that digital wallets are ensuring funds are used for their intended purpose and mitigating fraud. Thank you for your time. I'm happy to entertain any questions.
Representative Provenza has a question.
Thank you, Mr. Chairman. What is the cost of a contract to work with a company like yours?
It's hard to give a firm number because some of the services that we offer are a la carte. I know often that these bills will say that 3 or 5% is set aside for administrative fees. The amount that it costs to use ClassWallet is usually well below that amount.
Good.
Thank you, Mr. Chairman. And then, so the process of what you have in terms of kind of like your store, are you contracting with specific companies? So family needing a specific thing, if it's not in your vendor contract with a certain company, I mean, how does that work out?
So we have over 85 e-commerce vendors. So I think of them as big box stores. We have Staples, Best Buy, Scholastic, Lakeshore Learning that are fully integrated today. And then for the local vendors, typically when we launch a program with the state, they'll give us a list. Maybe they already have a pre-approved list of what private schools are okay and what tutors are going to be allowed on the platform. We'll get them loaded in. And we're always adding e-commerce vendors who are willing to help basically do the work to integrate in with ClassWallet.
I'm sorry, Chairman Scott has a question.
Yeah, Mr. Chairman, I take it what you're doing is you're saying you'd sell a service to administer this kind of a program. My question is, we've got some areas that just don't have the online service. How do you deal with somebody who doesn't have or doesn't choose to use the online service?
Right.
Mr. Chairman, is the question to those who may not have internet service or who choose not to use ClassWallet altogether?
Do not, Mr. Chairman.
Go ahead.
Do not have or do not choose to use the internet service.
Okay.
And we've got both.
Okay. Yes. I know in some cases where it might be a constraint for families who don't, they can do it on a mobile device or a desktop if they're using their ESA funds for a private school tuition, for example. That private school will help them do that transaction through ClassWallet. They'll help them with at the school to actually facilitate that transaction. We also have a very well-staffed customer service department who can help them walk through that. I can't speak, personally, I can't speak to how often we run into situations where families are unwilling to participate in it. I'm sorry, I don't have a better explanation.
Further questions? Thank you very much.
Thank you.
Next.
Thank you, Mr. Chairman. Nathan Winters, President of the Wyoming Family Alliance. I wanted to give just a few data points that our research team at Wyoming Family Alliance have put together, and then talk a little bit about the bill. So just when it comes to the discussion of non-public educational institutions, right now it looks like, and what we did is we looked at a 30-mile range outside of that specific zip code. We currently have a total of 31,168 children aged 19 and under residing in 29 zip codes within Wyoming who have no access to non-public educational institutions. And we can give the data later on. Then we have about 3% of all K-12 students. That would be roughly 27,008 who are currently enrolled in private schools. Just as a by the way, at $3,000, that would total about $8,124,000. That, of course, 3,000 is extremely low. I'll talk about that in just a moment. That's 3%, by the way, that are enrolled in private schools. The national average is around 10%. Then also when it comes to private school tuition, the average private school tuition Now, and I'll tell you a reason why these numbers are skewed in just a moment, is roughly in the state of Wyoming, $9,064 per pupil per year. And of that, the average elementary school is about 7,060, and the high school average is around 19,000. Now, we also took a look at this number. We have a couple of massive outliers that skew the data toward the upper end, primarily because of schools, private schools in the Jackson area. That number drops down much closer to $6,000, and for what it would normally cost for a mean average on private school education. In general, I am very for education savings accounts, appreciate them very, very much. I really liked the bill that came to you guys last year. This bill has some substantial similarities, but also some substantial differences. And so I wanted to talk about a couple of those. One of the concerns I have is for $3,000 per pupil. I think almost everyone has addressed that before. That would be too low, according to the statistics that we have seen, to actually help an indigent family. Not only that, there's a lot of people that are not considered in this bill as well, and that is what we would often call the working poor. Individuals that do have a job, but when it comes to the amount of money that they're getting in as a family, but what they have to put out for cost of living, to have any sort of margin to actually fund education is very challenging. And so by putting that number that low, it would be very challenging. So I wanted to bring that up. Also, 250% of the federal poverty level, because of that, because of the cost of living, it would likely be very low and would help very few as well. There's a couple of things you could do. One, you could eliminate that metric altogether. That is a policy decision for you guys to make. But the other would then be to change that standard to some completely different kind of percentage or metric. And so those are the funding areas where I have major concerns. The other thing too is on the testing. I think that if there were a way to maybe talk about a nationally recognized test. So I have extensive experience having graduated from private schools and all throughout my youth, and then also having my children in a private school now. I do know how they work. Many of them will use things like the Iowa Achievement, the SAT, the ACT. They use a lot of different nationally recognized standard tests. And so there might be a way in which you could talk about a nationally recognized test and make it broad enough to accommodate where many of those schools are. So with that, Mr. Chairman, I appreciate your time and we stand for any questions.
Good job. Questions?
Mr. Chairman, could you repeat the figures on the cost of the private tuition, especially eliminating the outliers? You talk too fast for me to take notes.
Yes, sir. Thank you, Mr. Chairman, and through you to Senator Scott. I appreciate that very much. I get a little excited. So just so you know, these statistics come from some within our own research department and also a source called the Private School Review that is just broad. It's not leaning in any particular political direction. So let me go back to those statistics. The average private school tuition is right around $9,064 per pupil, with the elementary school average being around $7,060, and the high school average being around $19,067. That's for the 2022-23 school year. The national average, I didn't throw this out, but this might be of some assistance to you, Senator. The national average is right around $12,187 per pupil per year, with elementary schools being around $11,191 and high schools being around $15,793 per pupil per year. Now, in the state of Wyoming, we have a couple of outliers. And so because finding the actual mean average was far more challenging, what we could say it was above 6,000, but much closer to 6,000 per pupil. And then a lot of private schools that I know of, now there are some others that are very different, but a lot of them don't actually charge more for high school than they do for elementary school. Now, the reason why that number is very high for high school is because the number of private high schools in the state of Wyoming are actually very limited. one of which is a very prominent school in Jackson. And so that's why that particular number is so high. It's because many schools, private schools in the state of Wyoming, either go to 6th grade or 8th grade, and there's very few that actually go all the way to 12th.
Further questions for Mr. Winters? Thank you, sir. Good job. Next.
Hi there. My name is Jessica Evans, and I'm a graduate student at the University of Wyoming, speaking from a taxpayer and longtime resident of Wyoming. I went through the K-12 system, graduated from a community college, and graduated with my bachelor's at the university, and now am pursuing my master's. And I'm not here to talk about like how much I owe for my public education. So I just have some questions, comments, and concerns for you all to ruminate on when you are considering this piece of legislation. The first question that I have is, who are the people who are actually going to be getting these funds? Whether it's a religious institution or a corporation, as a taxpayer, I do not feel comfortable lining the pockets of private entities or religious entities. And I've been paying taxes for a long time. So another thing that I would like you all to consider is that with this bill, we may actually be furthering the allocation of wealth and privilege to just a few people. And that, I feel, goes against what Wyoming stands for. The people who are working in public education, I believe, are going to suffer if this bill goes through. I have a question for you as well. What resources do our public education system have? What is it lacking? And would these general funds be better served in improving what we already have? And then, do we actually have the resources in the state to fund a program that doesn't really feel necessary because we already have education that could use some improvements? The next thing is, what are the educational standards of these private institutions? As a public taxpayer, I don't feel very comfortable paying for religious institutions to be teaching something that is not monitored. I don't really believe that creationism should be on a public education dime, on a general fund dime. So again, this just comes back to, how does this separate the church and the state, whether it's a general fund or not? It's just ridiculous. So, and as far as the poverty line, who's responsible for feeding these kids in these public or these private institutions? If these kids are under the poverty line already, what are we doing to take care of them outside of just partially funding their education? Do they get free school lunch there? How much is the parent actually going to be paying for these kids to go to this school? And then what about the services provided in these private institutions? Do they have access to counselors? Do they have accesses to health services? The next question that I have is, are the students going to be able to stay in the school district? Are they going to have to travel? Again, how much of these expenses are going to fall on the parents eventually? And then, should we be worried as far as like corporal punishment in these private institutions, or how individuals are reprimanded? My next question is, who are these institutions accountable to? Is it the state of Wyoming? Or because it's a private institution, do they not have to be accountable for what they're doing in these private institutions? And then I have one last question. On the agenda for today, we have a update for the retention and recruitment of teachers on this task force, and how is this bill going to impact the efforts of this task force? And then I have one final question. If these resources don't fund private schools, then could they go somewhere more useful? Because the state of Wyoming is already struggling with monetary resources as it is, and could it be used for something better and more productive for the entire public and not just a few? Thank you.
Okay, thank you very much. Go ahead.
This will work. Good morning, Mr. Chairman and members of the committee. My name is Caitlin Lane. I'm a State Advocacy Director for Ed Choice. I'd like to thank Speaker Summers and other members for working on this during interim and for bringing this proposal for you today. I sit before you as a former public school teacher, a mother, and an advocate for students. As of today, there are 78 choice programs in 32 states, Washington, D.C., and Puerto Rico, serving over 720,000 students, and that will likely exceed 1 million by the end of the year. In the 27 years since Ed Choice was founded, the criticisms against school choice have much remained the same. The evidence to refute those arguments has only grown stronger. There are 187 high-quality studies that analyze the impact of school choice on topics ranging from public school test scores to student achievement and attainment to the fiscal effects of school choice to school safety and civic values. 84% of those studies find that school choice has a positive effect, 10% find that school choice has no visible effect, and only 6% find any negative effect at all. The only other education reform that has been studied as intently or rigorously is charter schools. To quickly touch on two of those criticisms, I'll just briefly mention them to save on time. The loudest one that's often voiced, and we've heard it today actually, is that it drains funds from public schools. A report by the Reason Foundation noted that all but 2 states, Idaho and North Carolina, actually saw an increase their inflation adjusted average funding per pupil since 2002. And there's many studies that I can share with you that back that up. The second argument is often that choice harms public school performance. According to Education Week's Quality Counts Index, the 2 states with the most choice, Arizona and Florida, had higher gains on NAEP between 2003 and 2019 than states without choice. And generally, states with choice saw improved public school performance over the last 2 decades as well. If we put NAEP scores aside, the best evidence that public school outcomes improve comes from high-quality studies that research whether a private school choice program has a positive or negative effect on the test scores of students who remain in the public schools. The results of the studies have been clear. Of 29 studies, 26 of those studies, or 90%, found positive effects on public school test scores. 1 study found no effect, and 2 of those studies found negative effects. We could discuss the merits of school choice all day, and there are people that have way more information about that, including Leslie, who you've already heard from. She has far more experience than I do, but we've definitely limited on time. I'd like to respectfully encourage you to be thoughtful as you consider the proposal and the specifics of it, because that will determine whether your measure or whether or not your program succeeds or fails. I believe that you're likely going to consider a few things on whether or not there are changes to the bill before you. And there are a few things Ed Choice would like for you to consider as you move forward. A phased-in universal program, as we've seen in many states adopting universal programs to avoid the cliff effect, as many of you have alluded to. Award ESA values utilizing a tiered income system, perhaps, instead of just the 250 federal poverty line. No one's really mentioned it, but instead of the federal poverty line, many states have used the free and reduced lunch. It increases that amount. If you were to consider the free and reduced lunch if you switch to free and reduced lunch instead of the federal poverty line, you could actually include 81% of your Wyoming families instead of 16%. So it would drastically increase the number of families that could be included in that program. And I believe your superintendent also spoke to removing that amount. In addition to that, we would encourage you to remove some of the administrative red tape that mandates the 20% of audits. Trust your state leaders, trust your superintendent, make that permissive language that allows them to audit as needed instead of mandating it. That'll allow her to do her job and allow her department to do her job. As spoken before, and I believe Mr. Winters discussed it as well, statewide or national norm reference test, removing the designated ESA funds to be reserved for pre-K students. While our preference would be to reserve the program for K-12 students, we would be agnostic toward a program that was inclusive of pre-K without the set portion.
430.
And only include, or perhaps including pre-K students with disabilities, as Arizona's program has done. So, open questions.
Thank you. You guys have questions for Kate? Anybody? Thank you very much.
Thank you.
Go ahead, Tate.
All right, Mr. Chairman, members of the committee, my name is Tate Mullen, Government Relations Director for the Wyoming Education Association. We've got a number of concerns. I'm not going to reiterate the memo that went out, but there are a couple of points that I would like to raise and then some questions that I'd like to pose to you in considering this bill. First and foremost, this discussion makes for some odd bedfellows today. So one of the constitutional points that we're looking at is the amount, that $3,000 amount. The bringer of the bill discussed the necessity for testing to fulfill the adequacy component of what we need for public or for education in the state of Wyoming. We also need to discuss that equity piece, which is why we believe that that dollar amount should be towards the ADM value that we have, not the $3,000 value. The other piece that we would like to raise in 16.6, some of the language, and I think some of the more prominent, important language, is the word necessary. All right, so except for the necessary support of the poor. If you think about programs like TANF, SNAP, WIC, Child Care Assistance, those programs are designed for the necessary support of the poor because those programs provide services and products that those low-income families either don't have access to or have diminished access to. These families, because of public education, free, high-quality public education in the state of Wyoming, have access to education. This does not do anything about necessary. This is extra. Some of the things that I'd like to also discuss in regards to the correlation between SNAP, TANF, WIC, and Child Care Assistance programs comes in regard to how do we verify the income? This is a welfare program. We are expanding a welfare program. We need to make sure that the administration of this welfare program looks much like the other ones that we have across the state. When I reached out to the Wyoming Department of Family Services and asked them how often they conducted an income verification, it was typically 4 to 6 months. And what that staffing looked like was fairly significant, far above the 2 that we have in this bill. There were also pay stub requirements as well as banking requirements for those programs. The other piece here in terms of fraud, right? I'm glad to hear about this digital wallet. That sounds very intriguing, but fraud also happens on the front end, right? So making sure that that fraud prevention is there in terms of declaration of assets. If there is fraud in terms of that declaration of assets, what are we doing to make sure, what does that investigation process look like? What are the penalties? Again, talking to Wyoming Department of Family Services can be suspension of those services for a year or in some cases for the rest of their lives. One of the other things, and it's been brought up here, is the certification of the education service providers. It is a Wild West out there. And I'm concerned about the broad language in here. And I'm concerned about what that looks like for our students, because there are hundreds of cases across the United States where families and students have been defrauded. And when you look at what happens to those students, the learning loss that happens to those students, for every year that we lose that, you're talking about 3 additional years to get that back. So a lot of concern in what that certification looks like. I know there's going to be public comment if that's the route that we go in terms of rules to establish that, but that is a substantial concern for us. The last point that I would like to make here is that we talked about research in terms of private and parochial schools. One group of student body that really seems to suffer here are students on IEPs and special education students. There is a direct correlation to low income as well as students on IEPs and special education. What they have found is that a lot of these private and parochial schools just do not have the ability to provide that service to those students. So it's an area for concern for us. And with that, I'll stand for any questions.
Go ahead, Chairman Scott.
Chairman, very quickly for the record, you talked about the 3,000 needs to be closer to our current ADM figure for schools. What is that?
Mr. Chairman, Senator Scott, our assessment is if we think about how we looked at the charter school funding, right? The recognition that 80% of ADM going to charter schools was going to be unconstitutional. The same issue it presents itself here. It's a question. I don't have the answer to it, but my thought is that there's a question whether that $3,000 violates the adequacy and equity funding for that pupil. The ADM, Mr. Chairman, Senator Scott, I believe the last time I looked, it was 17.7.
Go ahead, Representative Provenza.
Thank you, Mr. Chairman. I just want to ask a follow-up question on the IEP and special education. I know when we've looked at charter schools in my area that there's just a dramatically different number, percentage of students that fall within that range. And so the concern is that the number of students that fall within, that need special education or IEPs and are staying in public school, which has an increased cost, yada, yada, yada. Are these schools taking in the same percentage of students? Are they taking in any students that have special needs? Do they not qualify? So going back to your point of people living within these poverty levels and having kids that have special needs, how many, do you have any idea how many we're going to be leaving out because they're not going to be accepted into these schools?
Go ahead, Tate.
Mr. Chairman, Representative Provenza, I do not have the exact number, but what I do know is that private and parochial schools tend to not enroll as many special education students as are reflected within the general student population for localities. Special education students on IEPs, they have selective admissions, right? They are not under any statutes that say, hey, here's what you need to accept. So they can deny them. And then there are some that do provide services, but those typically are not to the level that we have in our high quality public education systems. And those are the students who are most in need.
Further questions for Mr. Mullen? Go ahead, Representative Berger.
Thank you, Mr. Chairman. Maybe this isn't a question for the association, but can a child with a disability be denied enrollment into a private school? Disability or race or whatever, economic status, I don't know.
Mr. Chairman, Representative Berger, the short answer to that is yes, they can be denied.
Further questions? Go ahead, Senator Brennan.
Just, I guess, a comment, and I apologize, I had to step out a second, but I just came in kind of at this tail end on students with IEPs and in private schools, and that they don't maybe always accept it. I'm like, again, I said I stepped in on this conversation, but I just want to say that sometimes these private schools are the best place for kids with IEPs, and I can testify to that personally. I have a son who would be on an IEP in a public school, but he's in a private school where he's getting the best education that for him and his learning needs. So these can be a very good place. And I think sometimes you see, he's not on an IEP because I bring together all the pieces that he needs and make sure that he's getting the therapies and stuff that might be taken care of in a public school. And so maybe we don't see the number of students that actually would be on an IEP because once you put them in a private school, they don't need an IEP.
Thank you.
Mr. Chairman, my name is Marcella Shaver. I am the Wyoming State Director for the American Atheists. Now, I've listened to all these discussions, but it's smoke and mirrors. We've got one governing principle, that's the Constitution of the United States, the Constitution of the State of Wyoming. And we are well, let me go back to Madison and Jefferson. Madison wrote the Constitution, Jefferson wrote the Freedom of Religion statute for the state of Virginia. Both of them were adamant that nobody should be taxed to pay for somebody else's religion. That's the founding of our nation. So what I hear today in discussions here is looking for all kinds of ways to get around it. I don't care how many buckets you put it in, how many bank accounts you put it in, or how many private companies you hire to administrate it. You're still laundering tax dollars from people who, various religions or none, to pay for somebody else's religious education. And you can't change the fact it's unconstitutional to do that. And that's all I have to say.
And you said you were state director for American, and then in spite of my hearing aids, I couldn't hear you.
American atheists.
American, which is?
Atheists.
Atheists. Okay, thank you.
I should have worn the t-shirt.
Thank you.
Hey, Mr. Chairman, thank you. Tyler Lindholm, Americans for Prosperity, Wyoming. I came up here in case your members wanted to sharpen their knives. No, I'm just teasing, Mr. Chairman. Mr. Chairman, members of the committee, we're on and in support of this legislation with a few caveats and a few amendments. Speaker Summers spoke to some of those amendments, and I just want to go over them really quick. But the main gist point from Americans for Prosperity here in Wyoming, which we have 3 offices here in the state of Wyoming, with Wyoming residents working for us, including myself. Also a public product of public schools. I'm proud of that. My children are also in public schools, but it's not like we really have an option. Well, I'm not independently wealthy. I buy cows for a living, so that's a problem. But Mr. Chairman, this legislation essentially represents and could inspire people to think differently about schooling. And I don't think that's a bad thing, to think differently about schooling, about what's possible when we move away from standardized schooling and that you have to do it this way, and could more move towards commoditization or individualized learning. We spoke about, and we heard about IEPs and how that's an issue. Well, with IEPs, I have a child with an IEP in public school right now. What do? Individualized learning. That's the whole point of what an IEP is done, to help that student best succeed. What a better opportunity to allow parents into that discussion to help direct their child's future in that regard. And so that's why we're in favor of this legislation. Specifically, I wanted to go over some of the amendments that Speaker Summers mentioned that we're in support of, increasing the amount to $6,000 instead of $3,000. I think that better represents what the current private schools are at in the state of Wyoming. Increasing the percentage to 300% of FPL, splitting the divide between pre-K and K through 12 to a 70-30 split instead of a 50-50. Speaker Summers talked about how that 50-50 was a placeholder. We would support a 70-30 split, Mr. Chairman and members committee. Removing the tip over back to the general fund, removing that, just keep the money there. I think it could be utilized in the purpose. Maybe we could look at models where we can invest that money, and then all of a sudden we've got a self-funding situation where we don't have to go back to appropriations every year and get beat up. I know all of you know what that's like. Not a good time. And then expanding the testing options to include the national, those nationally recognized tests. I think we've got the Wyoming test, and then we've got nationally recognized tests. I don't think anybody likes standardized testing. That might be actually the one thing I agree about with the WEA is teachers don't like standardized testing, parents don't like standardized testing, and for damn sure my kids don't like standardized testing. So maybe that's a topic for another day, but maybe we should just remove Wyoming standardized testing altogether too. I don't know. I'll just throw it out there. But with that, Mr. Chairman, I'll stand for any questions. Those are the amendments that we support. Oh, and also, if you wanted to at the end, throw in an effective immediately. I think that'd be really cool.
Questions for Tyler? Go ahead, Representative Berger.
Thank you, Mr. Chairman, and good to see you, former Representative Lindholm. Are you talking moving all standardized testing for all Wyoming children, or only private schools?
Mr.
Go ahead,
Chairman.
Mr. Tyler.
Mr. Chairman, members of the committee, I would remove it for all. Now, granted, we can't remove the national standardized testing because there's funding attached to that, and I'm pretty sure the superintendents over here would probably kick me in the knee pretty hard on that one. However, you can remove the Wyoming standardized testing and not lose that federal funding.
Follow up?
Go ahead, follow up.
Thank you. Are the private schools, I don't want to say afraid of testing, but I mean, I guess, are they afraid of the Wyoming testing? Is, to me, it's like, okay, if I'm a accredited group and we're really confident in our success rate for educating these children, I would be kind of like, sure, bring it on. Let's go. Test my abilities as a teacher, because my students, they're going to do well on this test. That's how I feel. But are they afraid of it, or are they, what are they afraid of as far as the Wyoming testing goes?
Good, Mr. Lindholm.
Yeah, thank you, Mr. Chairman, members of the committee, and to Representative Berger's question. I don't think they're necessarily afraid of it, but the folks that tend to homeschool or private school, they're very independent, right? And so all of a sudden the state shows up and says, you got to do this now. I think we heard testimony a little while earlier that there was some strong pushback against that. I know Representative Berger, you know public schools, you know them exceptionally well, and you know kids. And so we all know some homeschool kids, some private school kids, and by and large, for the most part, they're competing right at the public school levels, if not better. And so I don't think that they've got any reason to be afraid or anything like that. I think it's just the independent nature of that group of individuals. My opinion.
Further questions for Mr. Lindholm? Thank you, sir, for your comments.
Thank you, Mr. Chairman.
Gentlemen.
Mr. Chairman, Brian Farmer, Wyoming School Boards Association. Just want to say that I really appreciate the conversation today. I think this is a good topic to have discussion on and to talk about what people think of ideas like this, of innovations, of opportunities, and then to talk about challenges and then ultimately practicability. So, Mr. Chairman, I would submit that there really is in all of this a threshold question. And I commend the LSO for the memo on constitutionality. Is this constitutional? And there's really three basic questions about, is it constitutional? Number one, are the provisions dealing with religious schools, sectarian prohibitions, those sorts of things. Certainly, there's been good discussion about that today. The precedent in U.S. Supreme Court discussed in the memo, Espinoza case. At the end of the day, we have some ideas of where that might go, but the truth is we don't know. We don't know where that could go. So that's one question. The second question is, so what about this prohibition about giving people money? Can we do that? Can we give people money in Wyoming? Does our Constitution allow for it? And really, it sounds like the only occasion where that's okay under the Wyoming Constitution is when it's for the support of the poor. So what does that mean? What is support of the poor? Good discussion on that today, really good discussion. Just for your information, I know you've already talked a little bit about it, but you look at that 250% of poverty level for a family of three, that's $62,150. The number that's been out there for a family of four, $75,000. For a family of five, $87,850. According to the state of Wyoming, the median income, household income in Wyoming is about $68,000. The middle in Wyoming is $68,000. Is $75,000 support of the poor? Is that the poor or is that not? That's a good question to deal with. The third question is perhaps the most complicated question with regard to the constitutional analysis, and that's the whole question about the uniform system of education. And so there's a whole lot to talk about, whole lot to think about in that. Does any of this impact the 40 years of litigation in Wyoming and how we understand education funding? So the threshold question is it constitutional? Once you get past that, then there are questions about the administration of the program itself. How does one go about administering a program like this? I suspect what we'll be talking about during session will be some different versions, some different ideas, some different pieces of this. And we look forward to those conversations as we move down the road. I think at the end of the day, sort of the guiding principles that we look at is that when you receive public dollars from the state of Wyoming, they must come with accountability and they must come with transparency. School districts in Wyoming are demanded to show accountability, all kinds of transparency and data reporting. And so with those dollars, I would just encourage that we do keep those principles of accountability and transparency there. So look forward to continuing conversations. I know what we're talking about right now is likely to look a little different when we talk about it the next time. Thank you, Mr. Chairman.
Thank you. Questions? Go ahead. Oh, I'm sorry.
Come on, here we
Senator
go.
White.
Thank you.
There you go.
Thank you, Mr. Chairman. Mr. Farmer, does the School Board Association have an official position on school choice? And if so, what is it?
Go ahead, Brian.
Mr. Chairman. Mr. Beitman, I don't think that we could say as broadly as school choice we have a position. I think there are some elements of choice that our members are supportive of, and there are other elements that are not. Again, when it comes back to choice, the standing principle that we do have is that all elements of choice must come with transparency and accountability.
Follow up.
Go ahead, follow up.
Then feeding off of Representative Berger's question, are school districts afraid of competition? If you did take the position that you oppose this bill or something similar to it, what would be the harm in a school district actually having to compete for those dollars with some other education opportunity for the students that might better suit those students' needs?
Good.
Mr. Chairman. No, I don't think that school districts are or should be afraid of competition. I think competition within our system is what drives innovation. We have 48 different districts across the state of Wyoming. Those 48 different districts across the state drive innovation. Sometimes there's different ways of doing things, and we can learn from those. We do have choice programs within public education today, and many times those drive innovation.
Anybody else, questions? Thank you, Mr. Farmer. Grady, it's all yours.
Mr. Chairman, good afternoon, members of the committee. I'm Grady Hutcherson, 24-year educator at the second grade level in the state of Wyoming, and I now currently serve as president of the Wyoming Education Association. And I wanted to speak in opposition to this bill. And I don't need to rehash all of the different points that have currently been shared, but I do want to reiterate the association's concern that was highlighted in the memo regarding the current school finance litigation to the K-12 public school funds across the state, while at the same time we're having a discussion now about a bill that appropriates more money for education. So I think that needs to be taken into serious consideration and the potential implications of the current ongoing lawsuit. And with that, I'd stand for any questions.
Mr. Chairman, members of the committee, my name is Kevin Mitchell. I'm the executive director of the Wyoming Association of School Administrators, which is basically the superintendent's organization. And not really for or against the bill at this point, just a few comments. I've been involved in the school funding formula in Wyoming as an administrator even before the current funding formula. So I was with Dr. Smith and the MAP model to begin with, and actually was heavily involved as a committee member when this current funding formula is. And what we tend to do is reduce that very complex funding formula to one number and say, this is what we spend per student in the state of Wyoming. But that's not how that money is generated in there. And so when we're comparing what we spend per student using the current funding model, school districts are required to provide a lot of services that necessarily, well, certainly a homeschool parent doesn't have to provide. They don't have to hire staff. They don't have to have a building. And all of those things are provided for in the current funding model. A private school, I'm not exactly sure. But I don't know that they could, but they're not required to provide public transportation. That's a huge bill for some school districts. So I'm just saying, when we're talking about this, it's really not fair to say, well, all the private schools and or a homeschool parent are going to provide the same services. I think you're basically asking, we need to provide instructional services, which is a part of the current funding model. The other part I would say is, over time, there are opportunities to increase the funding in Wyoming by providing an ECA, and that's been chosen not to because we don't want to spend that money. But we created 3 new charter schools a year ago that are going to cost more money. And people say, well, that money follows the student. That's not true. Our funding model provides for funding outside of that. So for instance, you got to create a whole new school. That new school creates more money that the state's going to expend. Same thing with this. I'm not arguing about the 40 million, but I think that there should be transparency at some point in time when this body votes for this. I want to be able to ask my local representatives, my local legislators, did you know that increased the cost to taxpayers so many $1 million? Not just the question I asked wasn't answered, but is the 40 million going to pay for what the department is going to cost them just to start up this program and then to fund it annually? That total cost at some point in time should be public knowledge. I would stand for any questions. Thank you.
Mr. Chairman, you do have one online with their hand up right now. Sounds good. I am letting Amanda Weaver into the room.
Hello, my name is Mandy Weaver, and I'm testifying, or I'm making public comment as a mom. I'm a 5th-generation Wyomingite, product of Wyoming's public schools, and my own children are being educated in Wyoming's public schools. I believe strongly in public education. Wyoming schools are known for their excellence. It's one of our state's proudest achievements. A voucher system of any kind or any amount would have an extremely negative impact on our public schools. So why are we considering it? I have seen statistics showing the cost of these programs have far exceeded the original estimates, costing the states far more money than anticipated. Every single state that has implemented a voucher system has seen a steep and measurable decline in the quality of education. If we care about children and the future of our state, why on earth would we implement something that all evidence shows will cause harm? The Wyoming Constitution is clear regarding public funds not being used for private schools of any kind. We keep hearing about how parents need a choice in their children's education. The fact of the matter is, parents already have a choice. They have the option to pay for a private school education or to homeschool their children. State funds should not be used for this purpose. State funds should not be used for schools that are allowed to discriminate against students that they don't wish to educate, whether it's because they're disabled, more expensive to educate, or don't fit the specific standard of students these institutions wish to educate. Public money belongs in public schools that educate every student, period. My children are being educated in a smaller school district, and a voucher system would be the most harmful to schools like ours. There is no true school choice option for rural communities, and any funds directed that way will be funds that are not directed to making our public schools, which are the literal heartbeat of our communities, stronger. Small schools are always up against tight budgets, and losing any funding would have a serious impact. I strongly urge you to oppose any kind of a voucher system in Wyoming public schools. I am in favor of early childhood education, and I think these should be two separate issues. They shouldn't be lumped in together like this in the same bill. I'd love to see you support early childhood education as it strengthens children in our current public school education system. It's good for children and therefore schools and communities.
Thank you, Amanda. Do you have questions? Anybody have questions for her? Thanks again. Speaker Summers, you have comments?
Mr. Chairman, thank you. And I know I'm standing between you and lunch, but a good former colleague of mine that was the chair of health brought up some good questions about, who are the eligible students, how much, that sort of thing. So I have, during this whole development of this bill, talked to the director of family services, and I do have some numbers. And it was asking me, well, what percent can we make that would be a federal poverty level or be considered poverty? And so I'm just going to give you a few facts. So SNAP eligibility criteria is 130% of federal poverty level. Child care assistance financial eligibility criteria is 175% of federal poverty level. TANF preschool is 185% of federal poverty level. The National Institute of Early Childhood Research definition of low-income children is 200% of federal poverty level. They estimate that in 2019, approximately 5,337 Wyoming children met this definition. We, being the Department of Family Service, have estimated 3,400 unserved low-income preschool age children. Unserved means they are not enrolled in a TANF preschool or Head Start. That number may be lower because we don't know how many children are served by the WDE Title I preschool program. That doesn't mean all of those children would go to any one that we created, but we know that is the need out there, at least at 200%. If you go to 250%, then the need is greater. 300%, the need would be even greater. And so I just wanted you folks to know that I kind of did look into all those numbers. I just didn't. And if anybody wants that, I can provide you that email. So just let me know. Thank you.
All right, questions for Speaker Summers? Go ahead, Representative Clauston.
Thank you, Mr. Chairman. Speaker Summers, I guess my question came up from Ms. Wilson's comment about Department of Family Services already providing funding for our early childhood kids in need. So can you speak to that and how these two programs would differ?
Go ahead.
Mr. Chairman, thank you. So the TANF is one, right? That's the TANF preschools. And so that funding is provided, and that's the 185% of federal poverty level. And so what she did when she provided me this was this estimate from the National Institute of Early Childhood, and then subtracted the TANF preschool children and the Head Start children. So there's another, I'd have to dig up. I've got another email that explains how much money spent on all that, but I'd have to dig that out for you too, but I can get it for you.
Thank you, Mr. Chairman. Speaker Summers, someone had mentioned the idea of using the measurement of the free and reduced lunch program, and I don't really know how those numbers actually stack up, but do you have any thoughts about that versus the federal poverty level standard?
Speaker Summers.
Mr. Chairman, I don't. I used the federal poverty level because it got to this definition that the DFS director provided me, and it kind of stuck to some numbers I had. So that was the reason I did what I did. I don't have a correlation. We know that based upon this, the numbers I just provided you, that FPL, that free and reduced lunch is 130% of federal poverty level. So you can get the gist of starting that as your base. You just lift the boat from there. So that's your decision.
Further questions? Anybody? All right, thank you, sir. Okay. Committee, what's your pleasure? I'd like to make this a committee bill.
Mr. Chairman.
Go ahead, Mr. Chairman.
Chairman, I think this is premature to make it as a committee bill. I think we're going to need to work it. That's the final decision that we'll make. I think we need to think about amendments, carry it forward to the next meeting, and see if there are other competing bills, and deal with work the bills at that next meeting.
And we're also missing 2 people.
Yeah.
Okay. Anybody else have public comment? I didn't close it. Anybody? We'll close public comment. And with that, we'll go eat. Okay. We'll be back here at, Verizon says 12:49, so 1:49 an hour, 1:50.
I feel like we got off.